proceeding is allowed.
Item 2.
I have disposed of for the writ petition with certain observation and directed the trial court to dispose of the appeal, which is filed in 1988 within a period of 6 months.
Item 3.
Partly allowed.
Item 4. Item 5.
This is also dismissed.
Item 6. Item 7.
This is also dismissed.
Item 8.
I have dismissed the petition with certain observation, and I dealt with the judgments of Rasmita Patro and Duswant Kumar Budu.
Item 9.
What is it? Okay, in view of the judgment passed in earlier matter, this is also discussed.
Item 10.
Distinguish the judgment of judgment in Minketan, Dr. Minketan Pani, and dealt with Radhesham and Ajay Rajya and Asu Surendranathan, and pass a detailed order dismissing the petition and making certain observations.
Item 11.
Petition is dismissed.
Item 12.
Certain observation, I have disposed of the petition.
13.
Certain observation, I have disposed of.
Item 14.
Have dismissed the petition with certain observation.
Item 15.
Have disposed of the petition with certain observation. Okay.
16.
I am in the VC.
I partly allowed the petition, but I have called out the procedure to be followed when the document or articles are seized on the basis of Sundarbhai Supra. This judgment will be circulated to all the courts below, and the director, the department, forest, the state business directorate, excise department, forest department, and all the investigating agency to follow the guideline.
Milord, is
I
allowed.
beg pardon to mention, your lordship.
Yes.
This is in bail application, your lordship. In this application, IA has been filed by the petitioner on the for interim bail on the ground of illness of his mother, and he is the only son. After getting instruction, the matter was in list in Monday week list, but couldn't be taken up.
Which court?
Court number 3, old building.
What is the pressing urgency? It can be heard on Monday. Monday, I'll hear. Monday.
Interim bail for
Monday. Yes.
Can I mention?
Tuesday. Yes.
Can I make a mention? CMC
Yes.
matter assigned to court number 3, new building, because warrants have been issued for execution of fine. realization of fine in a criminal appeal. Can that be listed tomorrow?
There is a criminal appeal. Sentence?
Sentence is 10 years, but fine is also there. And because 1 month back the judgment was passed, now the court has issued warrants for realization of fine.
The realization has to be stayed, that's
Yes.
all. The rest of the matter can be heard, yes.
My lord, revision of new building court number 3. Where the lady has preferred this revision.
What is the urgency?
Urgency, my lord, date is posted to tomorrow before the London session.
What is the revision? Regarding-
Revision, the petitioner preferred here for passing the charge
Oh,
to discharge him. That is why
Tuesday.
One matter assigned to court number 3, my lord, that is CMP. The urgency is, my lord, I have challenged the CMP, challenging the order rejecting my petition under Rule 3, Order 39. Now, my lord, taking advantage.
When the petition was filed?
Petition was filed, it is already in list, my lord.
When it was filed?
So that the number is 466 of 2025. Perhaps 2 weeks back it has been filed. It was
Next week anytime.
wait for today, because my lord, now they are going to sell the land. That is the whole. If my lord, they will sold the land, my lord, not only the suit, but it is also the
Hey, what is the order against which you have come?
order. I filed an application for ad interim injunction, and expert ad interim injunction. I filed a petition under Rule 3, but that petition has been rejected.
Tomorrow.
Pardon?
Yes.
Tomorrow.
My solution section of the CMP, it was the last 3 April, my lord. On the question that lordship directed me to prove whether the person who died is insurance or with this. That is the only cross objection. I got the information that he is insurance. The case it is posted to jail over 16th, my lord. Yes, sir, tomorrow is my.
What will happen on 16th? Nothing is going to happen on that day.
Because in this interim application, the trial court directed that the person who died, he is the only legal successor to the deceased person. Because the first wife, second wife, children are all equal rights. There is no disparity between the Supreme Court decisions, both have equal rights. But the trial court said no. The sons of the second wife, they are separate
Okay,
successors.
Tuesday. Level.
Tomorrow.
Not tomorrow.
Today, madam.
Not
Yes, madam.
No, it's not possible, sir. See, I can't disturb my bench. My board I can't disturb like this.
Yes, madam.
It's not very urgent. Nothing is great is going to happen. It can be upset, no problem. Yes. What is the urgency? When have you filed this petition? When date? Huh? When have you filed? Last month. You waited for then weekly, then I can't tell you. I can't accept all the matters here and do it. Next week. Sorry? Okay. Take it.
Pardon to mention, my lord, petitioner mother is suffering for cancer, my lord. And finally, I for extension of interim bail. Extension interim bail, my lord, was 15th is.
When the interim bail
surrender date is 15th, my lord.
15th.
My lord.
Okay, please it on 15th.
Last.
Yes, please it. Okay. Yes. Anything? Or memos you give it. Good. Yes.
My lord, in this CM.
Okay. Yes.
Any mention from item 17 to 19? Yeah.
See, give the memo, we'll see. Call the file and we'll see. Yes.
Item 20, I pray for an adjournment, my lord.
Your lordship, item 19, I pray for an adjournment. Sohini Paul versus Republic of India.
19 adjourn on request.
The sub item 1 I have to pay for that.
Yes. 19 adjourn. Yes.
Item 20, I pray for an adjournment.
20?
20. Item 20.
20 on request adjourn. Yes.
21 to 27.
Well, item number 22
Lordship,
paper
item
adjournment.
19 sub item 19.
Well, item number 22 paper adjournment.
22
My lord.
on request. Yes.
Pardon, my lord. Item 26, my lord. Parties are to appear for compromise, my lord. My lord may take around 2 p.m., my lord.
Okay. Yes. Yes.
Item 28 to 41.
My lord, item 35, I pray for adjournment.
The request of
Item 13,
Yes.
item 39 on behalf of Mr. Mohanty, Suraj Mohanty, my lord, he has requested to make an adjournment to next week because he was not
Counsel
here.
for the petitioner seeks adjournment. Yes, 39. Yes.
Item 42 to 56,
All these matters will go beyond vacation. Yes.
57 to 64, 65 to 70,
Item 66 on behalf of Jamnath Rivadi. Kindly
66. Okay,
next date.
on the request of. You have not filed, madam, you have not filed requisites, it seems. Is there any stay? Madam, you have obtained stay, you have not filed requisites. I'll vacate the stay. Let it come at the term. I'll not do it. You can't do that. You have taken stay means you have filed requisites. Yes. Next.
71 to 77, 78 to 83,
No, item 81.
Yes.
I prefer instead of today, 23rd, my lord.
Now you don't decide the date. If you adjournment, you go beyond vacation. I can't adjust.
Well, the council, Mr.
Whatever. On the request of counsel for the petitioner, release the matter. After vacation, it will all whoever is asking for adjournment will go beyond vacation if there is no interim press matters. I am trying to get it listed. You don't want to argue. Let it go. Yes.
Pattern, my
Interim order is there, my lord.
Interim order is there.
My lord.
Then wait. We'll see. Wait.
Well, council, Mr. Shahid Anwar is appearing in this case. He has some
Whatever
personality.
you have taken interim order, you can't do that.
No, my lord, he has some personality, could not appear
Interim order
today.
Yeah, for the vacation report.
Pardon, my lord. Item
23rd, my lord.
Don't decide the date. Yes.
Item 83, 83, my lord. Kindly, on behalf of SK Dwivedi, kindly 1 week after.
The request of.
Sub item.
Three items is there. I am oppositive party for OP in all three cases. LRC.
Do you have an objection or
No, man. But the refer the mediation failed. First time listed today after LRC may after case.
Yes. Yes.
Oblige, my lord.
item 84 to 89,
89, serial number 89. Mr. Mishra is doing this matter, but due to his health condition, after 15th, any day, your lordship.
My lord, I am for the opposite party, item 18.
And you people always think of your convenience. You don't bother about the convenience of the court or the other people.
Your lordship fix any date.
It will go beyond vacation.
Interim order is there, so that's why I am the petitioner.
That's the reason I don't pass interim order.
My lord, I am for the
Then-
opposite party. Kindly take.
Do you
this
have
one.
objection?
Yes, my lord.
There is an objection.
On behalf of Advocate Ashok Kumar Pani.
Yes. Then you come. I'm not adjourned. I'm not adjourned. Yes. Yes.
90 to 98, 99 to 103,
Item 100. Lordship has fixed it to 7 for appearance at 2 p.m. my lord. And it is listed today. The lordship will fix it 2 p.m. or 16th 2 p.m. It will be convenient for both parties.
7th.
7th it was not listed because your lordship was
Yes,
not
yes,
sitting on that day.
The 16th, 17th.
16th ରଖିଦେଲେ ଦୁଇଟା ବେଳେ ରଖିଦେଲେ ସେ ଦି ଜଣ ସାରା
Okay.
both are lecturer.
Okay. 16th, at 2 o'clock. Okay.
Lordship.
I beg pardon to make a mention, my lord. Out of list, your lordship, may I submit, my lord?
Yes.
CRLMA 175, restoration petition, my lord. Number of times I have given member, my lord, allowed, but it was not listed. 175 to 176.
Okay.
CRLMA, my lord. Tomorrow, lordship, any lordship.
Tomorrow.
Add your lordship.
My lord, may I mention 101, item 101, quashing matter errors on the basis of compromise. The petitioner could not be present today due to some illness. Any other day, your lordship.
Okay, next week.
Item
102.
101.
29, 30 subject. Okay. Okay. Yes, item. Whether in indication.
Item 57.
Yes.
This, Your Lordship, this CMP has a very limited nature before your Lordships. My Lords, a suit was filed before the Civil Judge Senior Division Sambalpur. It was decreed in favor of the plaintiffs. Subsequent to that,
Who are you?
I am the opposite, I am the defendant in the suit and the appellant before this honorable court.
Yes.
Now, Your Lordship may kindly see, I filed an appeal before this honorable court arising out of this decree. My appeal was admitted. It's a statutory first appeal. It was admitted. And in the appeal, when I made a prayer before this honorable court, that the appeal is the judgment, operation of the judgment and the execution case which was instituted by the plaintiff be stayed, this honorable court passed the following order. Your Lordship may kindly come to page
86.
Annexure 5, page 86.
86, yes.
Order dated 21/6/2016. Has Your Lordship got?
Upon hearing the learned counsel.
Upon hearing the learned counsel for the parties, this court directs that further proceeding of the execution case number 9 of 2014, pending in the court of the learned civil judge senior division, shall remain stayed until further orders subject to the appellants depositing 30% of the entire decretal amount with cost before the executing court within 8 weeks hence.
Have you deposited?
Yes, Your Lordship. Your Lordship may kindly come to the next page. Page 88, Annexure 6.
Yes. You have deposited. Yes. What is the order now? Let us see.
Now, Your Lordship may see at Annexure 7 at page 89.
7. Yes.
From 2017 till 2023, it was not taken.
Which is the order hurting you?
The order hurting you, my lords, is at page 102, 7/3/2025. But it is a consequent order of this earlier order.
102. Yes.
Advocate for the DHR and advocate for the JDR are present and file the respective hazira. Issue writ of attachment fixing 4/4/2005 for attachment and 7/4/2005 for SR of the writ. On 4/4, we filed an application for time. We moved the Honorable District. The District Judge, my lords, relying on the overruled judgment.
The same execution petition was stayed.
Yes, this order has been passed in that same execution.
Petitioner is agreed by the order dated 7/3/2025, whereby the following order was passed. Page 102. Order. The advocate for DHR and the advocate for JDR are present and files their respective hazira, issue writ for attachment fixing 4/4/2025 for attachment and 7/4/25 for SR of writ. Then counsel for the petitioner submits that the petitioner was the defendant in suit number. Civil suit number 62 of 2009, which was decreed in favor of the plaintiff opposite party. Why the judgment dated? Judgment and decree dated? Judgment and decree dated.
Judgment dated
31/1/2014, passed by civil judge senior division Sambalpur in civil suit number 62 of 2009. The petitioner filed a appeal being RFA number 88 of 2014 before this court. When the RFA was heard, where is that order you have shown me? 80.
May I only submit one thing,
1 minute. You tell me first. 80, 84. Stay order.
Stay order, my lords, is the annexure.
Yes. When the matter was taken up for the appeal was 1 minute. The appeal was taken up for hearing on 21/6/2016. The following order was passed. Right on. Upon hearing the learned counsel for the parties, parties, this court directs that the further proceeding for the execution case number 9 of 2014, pending in the court of civil judge senior division Sambalpur, shall remain stayed and other orders subject to the appellant depositing 30% of the entire decretal amount with cost before the execution court within 8 weeks. Hence, the miss case stands accordingly disposed of. Pursuant to the aforementioned order dated 21/6/2026, the petitioner has also deposited has deposited the 30% of decretal amount, by Annexure 6 to this petition. The petitioner has placed on record the proof of deposit. When the matter stood thus, the trial court has now taken up the execution petition, and despite the order dated 21/6/2016, the impugn order has been passed. It appears that the trial court has proceeded with the execution petition on the basis of the judgment in Asian Restructuring Center, whereby the Honorable Supreme Court had Honorable Supreme Court directed the Honorable Supreme Court had directed that the stay for the proceeding shall be only operative for a period of 6 months. 6 months. The letter counsel for the petitioner submits that the trial court is oblivious of the fact that the Asian Restructuring judgment has already been
1920 or 2000?
has already been modified by the larger bench of the Honorable Supreme Court. Honorable Supreme Court. He has
It's a 5-year bench. Paragraph 19 and 20, last part your lordship.
Constitutional bench of the Honorable Supreme Court, and he has relied upon paragraph 20,
19 and 20.
19 and 20 of the judgment reported in 2024, SEC 267, High Court Bar Association Allahabad versus State of Uttar Pradesh. Regarding to the aforementioned, I have no hesitation to held that the order passed by the impugn order passed by the court below is not sustainable. Hence, the same is set aside, and the order dated 21/6/2016 passed by the coordinated bench of this court in RFN number 88 of 2014 shall be operative, shall remain operative. With this observation, the petition is disposed. Disposed. Yes.
There is already a stay of execution proceedings.
Yes.
Your lordship's observation clarified.
Yes.
Item 17.
Lord, may I humbly pray for urgence again?
Get it, don't worry. Yes. In fact, 4/4/2025 was the date. Today we are.
Yes, we filed an application for time. The trial court fixed it to today. And the learned district judge court also fixed it to today.
Yes.
May I please your lordship, my lord.
17.
In this case, the FIR was lodged by the executive engineer on 30/12/2014, making allegation that the collection agent of the NESCO collected the bill amount from the consumers and did not make deposit. And that on the basis of such FIR, the case was registered at Southern Punta Police Station for allegation of misappropriation of property under section 406, 409, 4010, 20, 467, 468, 471.
Yes.
In the meantime, 10 years has been passed. Witnesses has been examined. The present petitioner at that time was working as a SDO electrical of the division. The fault of the present petitioner is only lack of a supervision. But so far as the allegation of misappropriation and mismanagement of the records, it relates to the collection agent and
What is the stage of the trial?
Final form has not been submitted. I have submitted the 10 years ago. I am facing difficulties in my promotion.
1 minute. Yes.
Not submitted, that is, I have to tell you.
See, it is 2014 FIR. You have not concluded the investigation.
Not completed as per.
Page 20 my lord, last order.
Page
20 my lord. Last order sheet my lord.
yes.
Record is put up as per order that is such another accused Ratikant Raut appeared before the court and filed Hajira through his counsel. No final form is received yet. Put up awaiting final form.
The second date was grandson.
Issue notice. And the check, oh, notice has already been issued. Notice has already been issued. It's 16/5/2024. No instruction.
No. Instruction that 2 weeks time.
Mr. Knight, then counsel for the state seeks 1 week time for appealing certain matter. By way of last and final opportunity, 1 week is granted, lease the matter after 1 week. Yes.
Date.
Item 18.
Date ma'am.
Date will be given. Yes.
Challenging the awarded seat 2024, the annexure for the petitioner has filed his challenge. Your lordship may kindly see the annexure 2. On the relevant date, the petitioner who is residing, working at LIC officer, he stayed at CORAM. The occurrence took place at Kanpur. There are near about 200, more than 200 kilometers from the place of occurrence. But somehow the informant lodged the FIR against the petitioner. That was challenged. Your lordship may kindly see the annexure 2. On the relevant day, he was working at the
Plea of alibi you are taking. Plea of alibi has to be proved in the trial. This is the law.
In fact, it's 354 CAC.
Whatever, but that is the what can I do?
Notice issued to the OP number 2.
Are you going to settle?
There are the intercept dispute with regard to the land. The plotting allegation.
The Arms Act, SC/ST Act, everything is what not is there. Everything is there. 354, everything is there.
506, 360 and
But if you only the ground is the alibi, then I can't enter.
If notice can be issued, then the matter would have been settled.
Simply issue notice. Yes.
Okay.
Item 21.
Item 21, I prefer to pass on, let's say.
Pass on.
Okay, let's.
23.
Please, Your Lordship, item 23, I am appealing on behalf of the petitioner, Your Lordship. Your Lordship, we have filed a joint affidavit, which is at flag B, Your Lordship. The disputes have been mutually settled between the petitioner and the opposite party.
What are the offences?
Your Lordship, the offences is section 448 of IPC 323.
And what are the allegations? Let us see.
The allegation is for house trespass.
So show me the allegation.
One second, Lordship. Your Lordship, may kindly see annexure 7.
7, huh?
57.
57, yes.
Yes, Lordship.
Tell me, orally tell me what are the allegations.
Your Lordship, the dispute is only a civil disputes, which led to multiple FIRs, Your Lordship.
What are the allegations I am asking? Except that you are saying everything.
Yeah.
What are the allegations?
Pursuing trying to possess the land.
Let us see. Sir, I am asking you, what are the allegations against you?
Sir, the allegation is of house trespass, voluntarily causing hurt.
I understand it. What are the allegations? I understand the sections. Tell me the fact. Tell me the fact.
Yes, Your Lordship. Your Lordship, the petitioner is in a criminal miscase challenges the initial criminal proceeding and pray for quashing of the order of cognitions dated 23/11/2020.
I think you have not read. You just read. I am passing it over. Please
Yes,
read
Lord.
what are the facts and tell me.
Okay, Your Lordship.
What exactly has happened.
Your Lordship.
Okay, I am
bless.
just passing it over. Just read
God
it
bless
and
Your
talk.
Lordship.
Yes.
24.
Yes. What is that? pass over.
25.
This is a case on the way of compromise. On the last occasion, my lord directed my friend to take instruction.
Yes. Have you got the instruction?
You have written letter.
Huh?
You should have some time. You have written the letter.
What? See, 1, 2, 3, 4, 5 dates.
Only short time. As the last one.
The 5 dates you have taken.
Sometime.
There is some limit to this, all these things.
The matter has already been settled. So the instruction.
Why? When have you written the letter? Tell me.
7 to 25.
7 to
25.
Today we are in April. Who is that officer? You tell me. Tell him to be present in the court. We are not under the mercy of the police officer.
Yes. You will also have some time. Then
Why are you defending
Any
this kind of
certain
officer?
period.
Those who are not giving
No.
instruction to you?
any shortest period. Any shortest period. You will also.
Week quarter. Mr. Janna, Mr. Naik, Learned Council for the state, seeks last and final opportunity for obtaining instruction. Least the matter next week. So, yes.
27.
Yes.
I am praying for Passover.
Passover?
Yes, ma'am. Oblate fast.
28.
Yes. 28. What is happening? Nobody is there. Yes. Passover.
On behalf of Mr. Naik, 15 days time.
Item 28.
Sir,
Passover. Passover.
One pass.
One Passover means 2 o'clock. Huh? In between, you don't ask me. Yes.
29.
Passover. Passover. No problem. Yes.
But OP number 1 initiated a proceeding under section 138 NI Act against me on in the year 2017 on 22nd
Yes.
February 2017.
Yes.
And initial statement in shape of affidavit was filed on 4/3/2017. Accused also appeared on 6/6/2017. The entire before your lordship, flag A.
Hmm.
And for evidence, it was posted to
Not entire order sheet, sir, except one page proceeding. That is 17/1/2024. You have not filed a single document.
my lord.
You have not filed any document.
The entire certified copy of the order sheet
When
is
have you
there.
filed? When have you filed? Along with the petition, only one annexure.
I have filed on the 7th. The receipt is here. And it is also noted in the margin.
Proceeding I got it. Yes. Proceeding is there.
Yes.
Yes. Which proceeding you are agreed by?
Proceeding 219 of 2017, 1cc.
You are agreed by what?
Till now, after initial statement, till now, there is no evidence has been adduced by the complainant.
What do you want?
So I want that it should be quashed because for last 8 years I am unnecessarily tortured due to false implication.
No, if 138 case, if he is not proceeding, it will be dismissed.
But in spite of my application, it is not dismissed by the
Petitioner notice was issued.
and his
Okay, petitioner is an accused in 1cc case number 1cc case number 219 of 2017 initiated by the opposite party under section 138 NI, which is pending before the court of JMFCCT Cuttack. Learned counsel for the petitioner taking me to the certified copy of the proceedings which has been placed on record. Submits that the complaint was filed way back in February 2017. The complainant is not at all taking steps to proceed with the matter, except recording the initial statement. The trial court has been adjourning the matter time to time, due to the time to time giving giving unnecessary opportunity to the complaint. The tendency of the case is the petitioner has been facing the ordeal of the proceeding since 2017. And on the ground, the petitioner seeks relief of the court and person of the issue notice to opposite party written within a week. Within a week. After file the process. And watch it. Yes.
Request to notice to issue.
Yes, yes, I have issued. Yes. 30?
Item 30.
Yes, madam.
Lordship, I'm seeking quashment of the proceeding on the ground of acquittal of all the co-accused persons who were acquitted on 11/8/2022, and charge sheet has been submitted against the petitioner. He was absconded. Charge sheet. Yes.
Yes.
I am not amending the charge sheet.
What are the offenses?
Offenses are, my lord, 395, 25 Arms Act, 27 Arms Act, and read with section 3(4) of this explosive substance.
There you are absconding.
Yes, I was absconded.
His name is not in charge.
Yeah. No.
Not in charge. Then
No, my lord, subsequently charge sheet has been filed in the split up record, that is in GR number 9.
then naturally you are absconding.
NVW was issued.
But how will you substantiate? All the accused persons have been acquitted.
Acquitted.
How will you establish 395? I'm asking you, how will you establish 395?
It depends upon the fact. What are the allegations?
How will you establish 395 if all the accused, single accused is there?
What is the specific allegations?
For 395, you can't establish 395.
FIR was unknown FIR initially.
You answer it.
Yes, yes. 395.
How will you establish 395? Everybody is acquitted. And even if he is absconding, and what will happen now? He can't be alone, he can't be convicted under 395.
25 Arms Act is there.
Oh, that's a different thing. I'm talking about 395. That is a substantive offense.
Yes.
That's the problem. Will you file response? What I'll do is is there any NBW issued against you?
My lord.
I'll cause that NBW, go and target the trial and finish it up.
Lord, trial has been split up and all the accused person has been.
I know, but your trial I'm talking about. You are
my
absconding. You will be acquitted definitely because 395 is not made out. Only Arms Act and all. Find Arms Act also this will be acquitted.
Yes.
Let us see what are the findings.
My lord. That is annexure 3, my lord.
Come to the finding.
The rest of the accused, from the accused, raised accused person, the stolen article were seized and they were.
Show me the findings.
To page number 93, in this case, the identity of this person were not proved. Identity of the seized property is not established. There is no evidence to prove that the seized property is stolen property. Also, the seizure made from the accused persons is not proved in the CD wide. MO number 1 is not utilized by the prosecution to link the same with the accused person. The seized gold ornament and the cash and the CPU in the case is not proved to the stolen property and not proved as the property of the said bank. Nothing has been proved in case of against the petitioners. Rest of the co-accused and the petitioner. Therefore, in my lord 97, page number 97, therefore, in consideration of the fact and circumstances of this case, as per the discussion made above, as per the discussion and findings of the provision, previous points of the determination of the offense under section 395 of the Indian Penal Code is not established against the accused person due to non-availability of the specific sufficient, cogent, consistent and fully reliable evidence against the accused person. Hence, the accused persons deserve to be extended to the benefit of document.
Do you have the statement of Pradipta Kumar Bailar?
Oh, I don't have it. I have to obtain them.
It is bank robbery. Madam, these people are acquitted on technical ground. You have to face the trial. Only on the technical grounds. All of you entered into the chamber of the branch manager and assaulted him, looted the bank and all this.
I have the deposition, but it is not certified.
He assaulted the attendant there. On technical grounds, yes.
This is the statement of that.
No, you have to face the trial, right? I will target the trial. Where is your charge sheet? Supplementary charge sheet? First charge sheet is? This is.
Charge sheet I have annexed.
Yes, right.
And the supplementary I have given, my lord.
How many accused were there total?
There were total.
Total how many accused?
Total 7 accused persons. 3 were acquitted.
And what about the other?
And so total.
What about the other accused person?
3 were acquitted and 1 is before our lordship. Another.
Absconding.
Absconding. 5, total 5, sorry.
Then I don't want to interpret. I don't. Petitioner is one of the accused besides 6 other in FIR number so. FIR number Ranpur. Case number 67 of 2003. The petitioner along with 4 others, 3 others have absconded. Subsequently, however, 3 of the accused persons out of 7 were apprehended. Charge sheet was filed for them on 2/8/2016 and they were put to trial. The trial court, the additional sessions that in ST case number 252/2018 by the judgment dated 11/8/2022 recorded an acquittal in favor of the 3 accused persons. Those faced the trial. The since the petitioner and other accused persons were absconding, for them, this charge sheet is filed against
The petitioner, my lord.
only alone.
No, 2 persons are there.
For them, as the supplementary charge sheet was filed on 31/3/2021 for alleged commission of offences, 1 to grant section 2, 395, 395 IPC, reading section 25/27 of Arms Act and section 4 and 5 of Explosive Substances Act 1900. The allegation against the petitioner is as allegation court no page 32. the case of the prosecution is not the paragraph. Okay. Where is the NBW? We should.
NBW, I think.
When? What is the name? Santosh. Yes. NBW when? NBW was issued.
NBW had issued against the petition. This court has no belief that I had said accused person absconded and.
Give me the date, madam.
I'm giving. NBW was issued on, my lord, 22/6/24.
Since the petitioner by so.
2024.
The petitioner was has been absent. NBW would have been issued by the court below. By order date 22.
22/6/2024.
2024. 2020. For the petitioner relying upon the findings of the sensations that in its judgment dated 11/8/2022, executing 3 accused submits that after the acquittal of 3 or so the accused persons, the petitioner is subjecting the petitioner to trial for an offence under section 395 IPC. Exercise, and she has taken me to the findings returned by the High Court from which paragraph you read, madam?
My lord, paragraph number. Paragraph, page number 93, last paragraph. In this case, identification of the accused. And my lord,
the last paragraph.
and page number 97, the last finding.
Please on to the evidence based on the court, as well as the judgment of court, the session says dated 11/8/2023 in case number 252 of 2023. It is apparent on the court that the present petitioner and it has the 3 others have been outstanding on the case. And the 3 accused who faced the trial have been acquitted on technical ground. The matter against the petitioners are serious in nature. The evidence led by the prosecution, vis-a-vis the 3 accused who has faced the trial, cannot cannot be made, will not endure to the benefit of the petitioners. As the evidence benefit of the petitioner. The prosecution has independently lead evidence insofar as the present petitioner concept. Therefore, I'm not inclined to quash the entire proceeding, relying upon the judgment, relying upon the finding of the additional assistant session judge in assistant session judge in the judgment dated 11/8/2022. It is inevitable for the petitioner to face the trial, However, the NBW issued by the court below by the order can be the execution of NBW can be dated till the petitioner surrender of his appeal before and resort to the remedy. The counsel for the petitioner submits that the submission second that the petitioners shall appear before the court below on or before 30th of April and resort to the remedy. It is open for the petitioner to move application seeking grant of bail after surrendering on the ground that the co-issue persons with this observation, the petition.
Time may be framed.
Hmm?
One time limit may be.
Since the case immunity from NFI registered on 6/4/2008, it would be expedient is for the trial court in trial is considered trial expedient. The trial court is very perfect to do and to see the trial considered expedient part. Yes.
Yes. Maybe cited, these two citations maybe.
What do you do with the citation?
I have,
Facts are different, madam.
that's on co-acute.
Which paragraph?
The last portions.
Yes.
From our Hon'Ble High Court. I have downloaded last night. Kindly taken into consideration.
Here is 147, 148 and writing and all. Which paragraph?
Last portion. That the prima facie case is not made out against the petitioner, and the rest co-accused person were
For the petitioner has relied upon which paragraph you are talking about? Para 5.
Yes.
Para 5 and para 6 are for you. Para 5 and para 6. I agree. Para 5 and para 6. I do. These are para 5 and para 6. He relied upon this. Okay. Okay. Yes.
31, so item 31 joint compromise affidavit has been filed. Both the parties, both accused and the informant is also present.
Sorry?
Joint compromise has been filed. Both the parties are also present.
I'm appealing.
What are the offenses?
Offensive lordship 341.
Allegation?
Allegation is during the puja immersion,
Sorry?
the accused persons, they heard some abusive language. That is a major allegation.
Are they here?
Both the parties.
Let us read the allegations. Yes. Come to page 11. Tokai hospital vasare kali gulo koriba saito mote hela pela kole. Ei samare mo driver to hoi mo gari ku mo hore sabu ku norbar mo pochre. Ganesh Subhadra.
During the puja, Ganesh puja immersion processions,
Who are the accused?
accused
Chittaranjan, who is Chittaranjan? Anu? Yes. Amar Kumar Mantis. Agugas. Kौन ହେଇଥିଲା? ମାଡ଼ ହେଇଥିଲା ଆପଣଙ୍କୁ ହସ୍ପିଟାଲ ଯାଇଥିଲେ ହସ୍ପିଟାଲ ଯାଇନାହାନ୍ତି what did the state charge sheet has been filed?
My lord.
Charge sheet filed? And cognizance has been taken, huh? Cognizance.
Cognizance, your lordship.
Taken. Charge has been framed.
Charge has not been.
Okay. After investigation, the police has filed the charge sheet on 48 by 3 for Reliance Commission of Offence 341 294 427 IPC. Subsequent thereto, the court has taken cognizance of the state about offences. When we put the charge is framed and the trial commenced, the parties have arrived at a settlement on the intervention of the court. On the basis of the settlement term, the petitioners are seeking the question for the entire proceeding. The petitioner and the opposite party are present in court, being represented by the identified by them. They have also filed the self-attested copies of Aadhaar card, which are taken under court. parties have filed a joint affidavit dated, joint affidavit dated 26/3/2025 inter alia. Inter alia stating again, para 2 to para
For 15.
yes, 50. Para 2 to 50. 2 to 50. The opposite party number 2 is the petition number 1 and 2 have also filed separate affidavit reiterating this tax. The petition number, the opposite party number 2, who is present in the court, on query from the court, submits that he has filed he has raised the FIR against the petitioner on certain provocation and misunderstanding. However, on the intervention of the local gentries and the government, in order to maintain peace and tranquility in the area, he doesn't want to further prosecute the Mr. Viveka Naik, that calls for the state submits that the nature of allegations are not serious, and the parties have they have filed a affidavit before this court. Therefore, there is no question regarding to the fact that the parties have submitted and therefore allegation against the petitioner. I'm up for the sensitivity that the subject to the wrestler to begin the trial in the fact scenario of the present case in the time to be expedite exercise. Therefore, the case of the petitioner is directly covered by the judgment of the Honorable Supreme Court in Gyan Chand, so. How much cost? Cost.
No.
They are hooligans.
No.
In the street, they create problem. They have to pay cost.
As per my lord.
10,000 each.
5,000.
10,000 each. Or 20,000. 10,000 to the informant and 10,000 to the bar.
5,000 lordship.
Subject to petitioners paying a cost of rupees 10,000 each, or to be 10,000 each. Out of the cost, 10,000 rupees shall be paid to the opposite party, number 2, and 10,000 shall be paid to the welfare fund of the High Court Bar Association. Yes, paid. And received. Yes.
Okay,
May I please, Your Lordship?
Yes.
Your Lordship, I'm challenging the FIR and charge sheet regarding to a vigilance proceeding, Your Lordship, which was initiated in the year 2009, Your Lordship.
Yes.
Your Lordship, the brief fact of the case is that a complaint was made against a fraud committed by a branch manager and a loan officer in a state cooperative bank, Your Lordship, in which allegedly they had granted loan in conspiracy with other officers by accepting fraudulent documents, Your Lordship. Your Lordship, the present petitioner is one of the employees of the PR department, Panchayati Raj department, Your Lordship. And the FIR was lodged in the year 2009. Thereafter, in 2015, Your Lordship, the charge sheet was filed.
Yes.
Till today, Your Lordship, cognizance also has not been taken, Your Lordship.
Yes.
That's the prime ground.
Yes.
2009 FIR, 2015 the charge sheet is filed.
Yes, Your Lordship. Till today,
Nothing is moving.
yes, Your Lordship. The petitioner has in the meantime retired and is not getting any benefits since the proceeding is pending, Your Lordship.
How many accused are there?
Your Lordship, I am representing only one, but there are
But how
33
many total?
accused.
Are anybody there? Anything accepting or anything of that sort?
Your Lordship, I do not have that.
I issue notice, let us first. Issue notice.
Your Lordship, what I was suggesting is if instruction could be sought for,
Yes,
Your
that's
Lordship.
what I. Issue notice, the Vigilance Council is directed to obtain instruction regarding the status of the.
I've served an extra copy.
Let us see.
33.
Obliged, Your Lordship.
Can you submit that 33 ma'am, submit that the present case is emanating CORAM and FIR registered against the petitioner and the other cases on 31/12/2009. After investigation, the charge sheet has been filed in the present case on 23/9/2015. However, till date, neither the cognizance of the offences has been taken, nor summons have been issued to the petitioner. Issue notice to the General Counsel to obtain instruction regarding the status of the case, least the matter out. Yes.
That is the.
Pleasure.
May I please, sir? The absconding charge sheet filed and NPW issued on prayer of IU, my lord. This is the absconding charge sheet. I am filing the passing of welfare, but my submission is the.
Petitioner, although is seeking quashing up for the entire and quashing up for the Kamakya Nagar PS case number 226 of 2023, which is pending before the court of learned HGM Kamakya Nagar. However, he submits that he will not be pressing this petition, rather reserve his right to educate the issue before the trial court at the appropriate stage. He further submits that the police has filed charge sheet showing the petitioner is an absconder, as a result of which the trial court, by order dated 24/7/2023, has issued NBW the petition. On instruction, he submits that the client will be appearing before the court on or before 30th of April 2025, and because of the remedy will have to be law until law. Subject to the petitioner surrendering or appealing to the court before on or before 30th of April, the execution of NBW issued by HGM Kamakya Nagar on 24/7/2023 in CT bracket sessions case number 88 of 2023 shall remain stay. With this observation, the petitioner will be filed.
Pardon, my lord, the PL. Or PS step Kamakya Nagar jagare porjam likhi desi petition na seta permit to correct my lord.
Court
Cost title na my lord.
Cost title Kamakya Nagar is there.
PS porjam cost title PS porjam. Chandan. Yes, ma'am. Yes, ma'am.
There. Why
Yes,
is
ma'am.
it?
Yes, ma'am.
Yes. Okay. So like. Yes.
My lord, in this case, petitioner challenged the order dated 13/2/2025 passed by the Session Judge Baleswar.
32? 13. Okay.
13/2/2025,
Yes.
February 2025.
Yes.
In this case, admittedly, petitioner was accused in the trial court in 138 proceedings. Opposite party is a complainant.
20%.
My lord,
20%.
my lord, this is statutory appeal. The opposite party complainant is not entitled for a single pay, my lord. So check the lekhe they are a friend. Petitioner is a government servant, teacher, my lord. ସେ ସେଠି କାମ କରୁଥିଲା ଗୋଟେ ଚେକ୍ କେମିତି ନେଇକି ଲଗେଇଦେଲା, that's the case. Is not entitled for a payment 40 lakhs.
But appeal court will decide that.
Appeal court is decided, but the initial stage, the London appellate court directed to petitioner to deposit 20% amount without considering LCR, without considering evidence.
Just see such a detailed order. Just see such a detailed order. What do you want?
I want, my lord.
By this order, the appeal could have been disposed of. Just see the order at annexure.
My lord, annexure 1, the ordering person, my lord. Accordingly, the petition of a respondent.
No, read from page 9. It's a very detailed order. Very detailed order running to couple of pages. And thereafter, the order is passed. It's considered order.
No, my lord, this is an interim order, my lord.
I know that interim order. Your allegation is the court has not considered while directing you to deposit 20%.
20%, my lord.
It's a detailed order. Court has considered each and everything.
No, detailed orders, but it's an interim order, my lord. Appeal in addition stage, my lord.
I understand that is the law 148, section 148.
But my
the presumption of innocence goes once you are convicted.
My respectful submission to my lord, if the trial court If the complainant had not filed 143 petitions, why 48 petition is maintainable in the appellate court?
Where is the law? Show me. If 143 is not filed, 148 is not, cannot be entertained.
Notice now asunto.
You should be happy that 143 was not filed.
Notice now asunto.
There is nothing. You tell me any ground, then I can interfere. Why unnecessary petitions are pending here? I don't understand. Notice is not routine thing. You tell me if there anything wrong, I'll immediately interfere and quash it. So show me where you, the trial court has
Monday
gone.
also, Monday. I'll file a decision. If the complainant not filed 143 petition before the trial court, the appellate court has is a bar to file 143 petition.
See, 143 and 148 are independent provisions. Merely because 143 is not filed, so therefore 148 will not file. That's not the law.
Session judge can consider it after considering the LCR fact, but in admission stage directed
You
to
take
deposit.
1 week time, but you will not get any judgment. Take it from me. You
Monday
want to
also.
search judgment? Definitely. You
Monday also.
bring it. It will help others also.
Monday.
Okay. You will
Monday.
simply adjourn for 1 week. Yes.
No, date may fix on Monday.
Yes. He'll fix a date. Don't worry. He'll fix a date. Yes.
36.
Lord, in this case, our prayer is very simple to expedite filing in the SDJ in the case of 2CC 16/2022. And NBW was issued against the opposite party number 2, but not been executed from the 2008. Kindly, may let's see the order sheet of 2CC/2002.
Who are you? You are the.
And the petitioner and in the trial court, the complainant is the opposite party number 1, that is the labor officer.
Raising of the natural dispute act towards it, the evidence is allowed by the natural tribunal. Therefore, the order not amount is not deposited. Therefore, the exclusion case is filed by the District Labor Commissioner. That is answer 2CC case number 16/2002.
Annexure?
Annexure that is page 39 or 5. District Labor Commissioner Jaspur Road is the complainant and filed against the CDM Jaspur. That case is pending since 2002. Meantime, perhaps that at that point of time,
Who are you? You are Prahlad Chaudhary.
39.
There is Prahlad Chandra.
30 is 36.
Labor name of the case. With the purpose. Why it is. Where is that order? 412 2020.
Only petition is 37 and also. The
Order
complaint petition
sheet.
is annexure 4, 37 and also.
There is the complaint petition filed by the labor officer.
You are the beneficiary.
We have the complaint.
You are the beneficiary.
Yes, employee.
Beneficiary of the award.
And the what fence?
Right. The petitioner is agreed by the long pendency of 2CC case number 16 of 2002 before the subdivision SDGM. SDGM, huh? SDGM, Jajpur.
SDGM Jajpur.
Exactly. The next.
I did that matter meantime transfer to them.
1 minute.
It transfer now, we have short instruction.
2CC case, the 2CC case has been filed under section 17 capital A of Industrial Dispute Act for implementation of the award dated 48/2001 in ID case number 110 of 1996 passed by the Labor Court Bhubaneswar on expiry of 30 days of its publication by the government of Orissa. The said case is pending, although filed on all the pending since 2002, but not being concluded as yet, even after the expiry um, of more than 2 decades, Hence, the petitioner is agreed. Petitioner is the beneficiary of the award level. You are the workman or the workman. The prayer made by the petitioner deserves merit.
NBW has not been.
And being innocent, I am inclined to allow the same. I'll give a direction to dispose it up, allow the same. Regard being had to the fact that the 2cc case is pending since 2002 without any result. The SDJM Jajpur is directed to do and to see that the 2cc case number 16 of 2002 pending before it is disposed of as expeditiously as possible, preferably within a period of 3 months hence, if there is no legal impediment. And the 3 months in accordance with the law, It is directed that the petitioner neither party to the proceeding shall be allowed to take unnecessary adjournment. Okay.
Not the complaint report
I know he is the beneficiary. Beneficiary of the award, being the workman. Being the workman, the award is in his favor. 17A award. It has to be executed. Yes.
Sir.
May I please, Your Lordship? Madam, in this case, I am praying for the stay of execution case by number 74 of 23 mile. Instead of order passed in CRP number 22 of 2020 as ex parte order, my lord. Thereafter, and the file an execution case 74 of 23 my lord.
Where is that ex parte order?
My lord, had annexed 2, my lord.
Yes.
Page 23, my lord.
Yes.
In this regard, my lord, file a petition before the family judge.
Have you challenged that ex parte order?
Yes, yes, my lord. In CMC number 3 of 24, my lord.
Have you got any stay?
No, my lord, no, my lord.
Then execution will go on.
No, my lord. I am praying for the stay of the execution order.
Why? If that order stands, then it has to be executed. How can I say?
My lord. The CRP
stay, you have to ask there, wherever it is pending.
Yes, my lord.
There is an ex parte
I-
maintenance order. There is an ex parte maintenance order against you.
Yes, my lord.
Okay. And you have filed challenge that order.
Yes, my lord.
Where have you challenged?
In CMC number 3 of 24, my lord.
Where is that?
My lord, by the annexure 4, my lord.
Election
4, my lord.
4. You have challenged there.
Yes, my lord.
You should ask the stay of the impugn order
Yes,
there.
yes, my lord.
Stay of execution proceeding there.
Yes, my lord. By the annexure 1, my lord. Filed and the learned court below was rejected.
Yes.
By the annexure 1, my lord. On dated 3/2/25, my lord.
Yes. What is the area now?
Pardon, my lord.
What is the area?
Area I don't know exactly area, my lord. But he was not giving any opportunity to hurt me, lord. But passed an ex parte order against me without my knowledge. The execution case, we came to know about the criminal proceeding.
Now you have challenged that order there. Ex parte order has been challenged.
Yes, my lord.
So then unless it is altered, there is an order against you, you have to pay maintenance. As simple as that.
Yeah, I am ready to pay.
Pay.
I am ready to pay.
Go and I'll stay, I will stay the NBW, you go and appear. And
NBW already stayed passed, my lord. NBW already passed. But the filing of the CMC number is pending.
I don't understand what you're trying to say. I'm not able to follow you.
My lord, in this regard, my lord, CMC, I'm challenging the order of ex parte order at CMC number 3 of 24, my lord.
Where have you challenged that?
Before the trial court family.
The trial court will deal with that.
My lord.
Why have you come here?
Thereafter, I filed a stay petition before the trial court.
Which was rejected. The execution proceeding is going on now.
Going on now.
That's what I'm asking. If the interim, the main maintenance order stands, then you have to pay.
For which, my lord, I'm paying for the stay of the execution order.
It can't be stayed.
Till disposal of the CMC.
No. You have to keep, it's the maintenance order. It can't be stayed. Like
Without giving an offer.
That court will look into it.
Without
7,000 rupees
to hire us.
7,000 rupees you have to pay.
Without
Area you may not pay, but you have to keep on paying
But I am ready to pay. I am ready to pay.
What is the area? I am asking you what is the area amount?
I don't know what is the area.
You should know it. What is the area?
But I am paying.
I can't say it without knowing anything.
To pay my one-time settlement. But he was not settled. Yes, my lord. Your lordship may kindly see.
I'll simply issue notice. Letter come. We'll see. If you want to settle the dispute, settle it. Okay, simply issue notice. Yes.
Till then, when you stay the execution.
I can't say maintenance order. Somebody's survival. Somebody's survival is questioned. 7,000 rupees you keep on paying for 1 month. What big deal? Least after 1 week or so. It has video. 29, 30, 30th. File the process immediately. The letter come, we'll settle it. Yes.
Till then, can you start?
Sir, how can I make you understand? It can't be said like this. Because in ex parte order, you have already challenged that order. That court has not stayed. How can I say it like this? Like
if the execution order is not stayed,
what will happen? You will be hanged. Because you can't pay 7,000 rupees, therefore you will be hanged. That's what you want me to say. It is matter of 7,000 rupees. Why can't you pay?
No, I'm ready to pay one
Yes.
time settlement.
Ready to pay, therefore I am issuing notice. Letter comes. We'll try and settle it here. We'll try and settle it here. Therefore, I am calling here.
Yes, ma'am.
Yes. 38.
Please, my lord. My limited grievance of this case, my lord. It is alleged on the date of allegation, the accused persons have scolded officer and they assaulted. Only I pray first hour, second hour. Bail. From the very weakness. Not just limited prayer to surrender, move for bail. But the question
When
is.
you ask this kind of orders, I start doubting.
No, doubting.
Serious thing.
No, doubting.
Where is the order of rejection of bail?
Bail with challenge.
Show me that order.
Seta anime.
2025.
You are challenging what?
Challenging passing of the prayer.
Petitioner, although is assailing the entire criminal prosecution initiated against him by in Napoli PH case number 23 of 2025 for alleged commission of offences responsible under section. However, Mr. Panda, counsel for the petitioner, submits that he would not press the petition, rather reserve his rights to agitate the issue before the trial court at appropriate state. However, the appropriate state. At the same time, Mr. Panda submits that the petitioner had. How many petitioners are there?
Here,
one petitioners, huh?
Three petitioners.
Petitioner had already approached this court for grant of regular bail application rejected.
No, no, ABL appeal. ABL appeal. Until not post.
ABL appeal.
ABL appeal.
BL appeal.
ABL appeal. ABL appeal 153025. 153025.
AB
Which one on 12 to 25.
that their anticipatory bail application has already been done down by this court by order dated so in so you know
12/2020.
12 to 2025.
On instruction Mr. Ponda submits that submits that his client would be appearing, clients would be appearing or surrendering before the court below on or before 30th of April 2025 and resort to the remedy available to them under law. It is open for the petitioner to move regular bail application to the trial court on all the grounds as have been raised in the present petition and any other ground available to them. If such application is moved, same for be considered by the courts below, plural courts below on the same day. With this observation, the petition is disposed.
May pardon one prime records be transmitted at the cost of the petition from Sinapalli to Nuapada at the cost of the petition.
I don't know whether records are there or not. How can I pass this order?
And the once bail application will be rejected.
Inside.
Wait, please, my lord. Lord, herein there are 7 petitioners before my lord. They have challenged order of annexed order of cognizance at annexure 1, my lords.
Yes.
My lords, the corresponding IPC offenses are 323, 341, 506, and 34 IPC, my lords. They have challenged the cognizance order. My lords, the entire allegations arises due to a land dispute. My lords, there is a demarcation between the 2 adjoining properties, and the allegations against of the opposite party number 2 is that we have tried to build construction over the said.
Yes, that is there, Lordship. While the construction work is going on the disputed land, there is
And issue notice,
yes, Your Lordship.
it can be settled. Issue notice. Yes.
Interim orders to control. Interim order.
Move application.
Deeply obliged.
Shall I refer it to mediation? Straight away. Let them come. I will 1 week, 2 week for a crore, so that we can send it. Okay.
Due to matrimonial dissension, the wife left the house and lost the information. And the criminal proceeding is pending. Within this time, they have detached. They have filed a mutual divorce petition. And both all parties are present.
I issue notice. You are
I am appearing for
okay.
okay.
Yes. Settle the dispute.
My lord.
The parties are here.
Parties are here.
Soumitra Parida. Yes, madam.
So,
For 50, 76, 354 and 354A, 350, the IPC matter.
Yes, 311 applications rejected.
It is a development at the PW1 and the present petitioner making a compromise matter, that the development.
What are the offenses?
It's the opposite for number 2.
Okay, let us issue notice. Yes.
Here, my lord, the petitioner is aggrieved by the order dated 23/9/2024, whereby, my lord, the learned magistrate, while imposing punishment, have punished for 30 days instead of 12 months, my lord.
Where is that?
My lord, that the NBW issue for levy of maintenance of for the month for 2,10,000 warrant was issued. That is for 21 months. But the magistrate can impose punishment for 12 months as per the section 125(3) of the CRPC.
Yes.
So magistrate, while sentencing punishment, has imposed for
30
only
days.
1 month, 30 days.
30 days.
That is wrong, my lord. He should have imposed punishment for 12 months, my lord.
No, ranging from.
No, my lord, I'm just placing the judgment of the Bombay High Court where it has been clarified.
Yes.
My lord, the 125(3) clause 3 says for 30 days, for 1 month maintenance, imprisonment is maximum 30 days, my lord.
You are interested to send your husband to jail or money?
My lord, he is not paying at all, my lord.
If you go to jail, how?
My lord, let him be there.
The scope of getting some money, that will also.
Let him be there. Even she was thrown out from the residence, and he is not paying. And after 30 days, he is going back to his place of my lord work. Your lordship may kindly glance to the para 13 of the judgment, my lord.
Let us see the provision first.
Provision, my lord. 125(3). If any person, may I read, my lord?
Yes.
If any person so ordered failed without sufficient cause to comply with the order, any such magistrate may, for every breach of the order, issue a warrant for levying the amount due in the manner provided for levying fines, and may sentence such person
for the whole or any part of each month's allowance for the maintenance or interim maintenance and the expenses of the proceeding as the case may be, remaining unpaid after the execution of the warrant to imprisonment for a term which may extend to 1 month or until payment if sooner made, provided that no warrant shall be issued for the recovery of any amount due under this section unless the application be made to the court to levy such amount within a period of 1 year from the date on which it became due, my lord. So, my lord, the 30 days due for 30 days for 1 month's maintenance, my lord, the punishment is for 30 days maximum. So that has been also clarified. While analyzing, my lord, may kindly have a glance to para 13 of the judgment. I am relying upon, my lord. This dispute is, my lord, is happening in my entire state. My lord, your lordship can clarify it. One judgment can clarify everything.
I will not interfere in this kind of matters. See,
no, my lord.
In any case, he is
my lord, I am not
for non-paying of maintenance.
My lord.
Do you want that he will remain in jail for 1 year?
My lord, no, my lord, that it is a continuing offense. My lord, it is a continuing offense. My lord, I am not on the, my lord.
He is a murderer.
My lord.
Or rapist.
No, my lord, he is more than that.
No,
my lord, he is committing, my lord.
He may not be in a position to pay.
No, my
lord. Who is interested to go to jail unless he's very hardly pressed?
My lord,
having that money doesn't mean that you would keep him in.
My lord, taking it in an emotional point of view, my lord, the point of law has to be decided. My lord, a point of law has to be decided. Your lordship may kindly, for a moment, your lordship may kindly have a glance to
you should be interested in getting the money. That's
para 13.
What are you doing, by the way? Let us see. What is this man doing?
My lord, he is an engineer.
Let us see.
He is an engineer.
If he is an engineer and
working in a software company, he is not paying the custody.
What are you doing?
My lord, myself. My lord, I am a housewife, homemaker.
Show me the objection to the 125 petition.
He has not filed objection. He has not appeared.
He is prepared to go to jail.
Yes, my lord.
Very good.
My lord,
after 2 months,
but he must not be allowed to, my lord, commit breach of the order. Your lordship may kindly see. Para 13 for a moment, my lord.
30?
My lord, para 13 of the judgment, my lord. The subsection 3 of section 125 of the CRPC empowers the magistrate for every breach of the order to issue warrant for levying the amount due and for sentencing the person for the whole or any part of each month maintenance remaining unpaid to the imprisonment for a term which may extend to 1 month or until payment if sooner made. Proviso to subsection 3 of section 123-25 restrict the power of the magistrate to issue warrant for recovery of the amount due unless application is made.
Each month's due.
My lord, that has been
1 month maximum.
My lord, that has been upon holistic reading of the subsection 3 of section 125. It is evident that the same provides for maximum imprisonment of 1 month for each month maintenance. For each month maintenance. So he has already issued.
I can interpret it otherwise also.
No, my lord, I am just
maximum sentence for each default is 1 month.
My lord.
And it's not necessary that it can be 1 day also.
My lord. Yes, my lord.
It can be 1 day also.
My lord. That is true. But he has not done that.
And you say that the maximum has to be imposed.
That's not the law. No, my lord. He has maximum.
For 1 year default, the court can
impose, my lord, maximum
12 days. 12 days.
12 days.
12 days.
But he has not done that.
Every month,
My
one day.
lord, the order is otherwise. The order is otherwise, my lord. My lord, the order is otherwise. He has.
I'll simply issue notice. Let us sort it out.
Yes, my lord.
I'll do that, but don't.
My lord, your lordship may issue notice. My lord.
One sentence.
My lord, more କହିବା କଥା, a law that let it be decided for all time to come. It is the impression of the judicial magistrate that the maximum punishment is 30 days for 1 month.
No, that's not the idea.
If your lordship will check up
for every month
on the administrative side, your lordship will find for every 1 year they are imposing invariably. All the magistrates.
It is not happily worded, but the order is correct.
No, my lord, he has issued levy warrant for 21 months. He has levied warrant for that. That is the wrong. Your Lordship, that is what I want to clarify. Your Lordship should clarify that for 1 month, it's maximum 30 days, and the magistrate can impose punishment as per his discretion. Your Lordship, that can be, a law has to be, I want that a law has to be laid down.
Okay, it's all right. I'll issue notice.
Yes, ma'am.
Let them. Yes.
45.
You keep it, and next date you will give it
Yes,
to that. The other
yes.
side come.
Yes.
To clarify.
Yes. Requisites
by tomorrow you
by tomorrow. My lord, a date may be fixed. My lord, my endeavor is to a law to be laid down.
But
My
see,
lord. It has to be clarified because I am, my lord, I am being a trial court practitioner. Every day I came across the magistrate mind is 30 days the maximum punishment.
It's all right, but you could not persuade the lower court so far. And you want to shift the burden on me.
Yes, my lord.
You should have persuaded them.
No, my lord.
Okay, the lighter side I will do.
My lord. Oblige, my lord.
45.
Your Lordship. This is the application challenging the cognizance order, Your Lordship, passed by the learned STJ in Hindor against the present petitioners.
Yes.
Lordship, the corresponding offences are under section 498A, 294, 323, and 34 of
I'll issue notice 498. Issue notice, yes.
Some of the witnesses in the meantime already been examined. Some of the witnesses already been examined in this case.
It's all right. 498.
Yes, Your Lordship.
Don't go by the strict law. If they can settle at any time, let it settle. If they don't settle, then we'll see.
Your Lordship, if I may submit, Your Lordship, in the examination, she has admitted that she is living separately.
I'm just issuing notice to explore the possibility. Otherwise, in strict sense, he's correct. If the trial is going on, why should the court will interfere for it? So therefore, I'm just issuing notice, let her come. We'll see. Yes.
46.
See, I pray for tomorrow. Today's development, they have settled the matter. Tomorrow, informed will file appeal.
What are the offences?
376 2N, 323 294 503. Both are software professional. They live together for 5 years, and that's some dispute.
But tomorrow they are going to settle the dispute.
Today already they have settled what I got issued. Tomorrow she will file appeal.
Have you told that I filed the petition, court has asked you to settle? I'll simply adjourn it to next week.
Tomorrow.
Not tomorrow may not be possible. Tomorrow is very heavy day. Very heavy.
Monday.
Oh, Tuesday, they've settled the dispute. What is the age of this boy?
28 years.
You have not implemented, see, you have not implemented the opposite party.
The problem is prosecutors cannot be implemented as a party.
Informant, at you right, informant? That is how you have to implement.
Yes.
Name and address you can't give. But you have to write informant victim.
Yes.
You implement. Mr. Moon, learned counsel for the petitioner, seeks leave of this court to implement the informant of the victim in the present case is opposite party number 2. Issue notice. I am issuing notice. Issue notice to newly implemented party number 2. Mr. Moon further submits that the parties have also have already arrived at a settlement. Issue notice to opposite newly implemented opposite party number 2, amended party 2. Do it right now and issue notice. File the process P and list it on 17. Yes.
47.
Right, Your Lordship, my lord, primarily the case reveals the civil nature. May I invite my lord's kind attention, page 22, my lord. The police investigated the matter. Very important, my lord. Page 22, my lord, 22. My lord, second paragraph, internal page 6, second paragraph, from line from the top, my lord.
Yes.
This is one land between certain Haryana, etc. Plot number very important. Plot number 349. Area, etc. Then name of the CORAM Sutra. Then, my lord, 7th line. Very important is 7th line.
Yes.
7th line, one Debasis Mandi Amin. He went and demarcated the land and found the land belongs to the present petitioner, the landowner. But the dispute arose under Bachuda scheme, drinking water department proposed for pipeline providing water to this basti. Then, my lord, under the scheme,
if the land does not belong to the government, or in other words, the government has no land, then under clause 6, they will go for a direct purchase from the landowner. Therefore, the Amin found, made a report to the competent authority, belongs to the, so accordingly, authority could have proceeded for direct purchase. But since the Amin stopped the matter and reported this opposite party informant, they thought that at the instance of mine, the landowner, the entire providing water stop. So the dispute arose, then they went for.
What are the allegations?
Allegation is the present petitioner's son assaulted, scolded in filthy language, assaulted. This is the allegation. But even in the complainant, it started narrating this dispute. Apart from, therefore, when this arose,
the dispute which you have narrated, that may be the motive behind attacking. The attacking is the offense, not the
no, but
motive is civil.
my humble submission,
The conduct is uncivil.
my humble submission, my humble submission, then the aggressor, the aggressor is the informant party, because they thought that I halted the proposal, so they came and scolded me. There is the narration in the complaint that
ACSC
360 arranging on to be complaint.
and civil suit is also pending, Milord. Civil suit annexure 3C,
Yes, I have.
23, civil. Injunction. Injunction is order is status
Who has
quo.
filed? Who has filed this injunction?
Myself, because I have to protect, because unless that happens, then I will not, even if the government will take direct purchasing.
Yes, father of the present petitioner also.
Who is the informant here?
Informant,
Sukanti also, that is.
yes, Jayanti.
Jayanti.
But the complaint case was
Who is the
registered.
informant?
Yes,
Is the defendant in the suit?
yes, the defendant is
One number?
12.
Jayanti Malik, the 12.
12.
When the suit was filed and
Sold in the year 20.
this is pending.
Yes.
And the fire
Pending injunction order is there.
The fire is?
These are Korea.
Yes.
Last down your also, that is.
What
is happening then in the fire?
Pardon?
Charge sheet is filed.
Charge sheet is filed. Charge sheet that I am reading from the charge sheet. That I is reading.
Thereafter nothing has happened.
That my president, the charge has been framed. So this order is against the framing charge. I raised all this point. Mechanically, the court has when the court comes across.
Let us issue notice.
Not sufficient.
Yes. But then in interim, I have filed. I will make an application saying that oblige or deep oblige or
48.
My date of Belgium.
Give the dates. Give the dates.
21st November 2024.
Speak little louder.
12th January 2024, NBW dated 21st November 2020.
49.
49 17 June 2013. NBW dated 1st February 2024.
I may pay from local bar, ma'am. Item 49, my lord, I pay for paying the amount at local bar.
Local bar.
50.
Item 50, 2012-2024 is the date of interim bail, your lordship. And 4/1/2025 is the date of NBW.
4/1/2025.
Yes, your lordship.
51.
25th March 2025, because of the non-appearance of the petitioner, my lord, at the stage of recording of the statement of the accused, my lord, the NBW has been issued, my lord. 25th.
The petitioner did not appear, and NBW issued on 25/3/2025. 500, yes.
54 also same.
50?
Same accused, 54.
54. Okay, 54, same. Yes.
52.
Your lordship, item number 52 and 53 are of the same petitioner.
BLKB. They have not mentioned the date of the bail, but
He will tell
NBW
with
The petitioner was bail on dated 12/1/2016 and the NBW was issued on dated 21/12/2022.
and what about 53?
The date of bail was on 6/5/2016 and NBW was issued on 21/12/2022.
What is your name?
Pragya Arina Das, Your Lordship.
I don't know. Yeah. Okay. Hello. Yes.
55.
55, my lord, bail was granted on 16/3/2022 and NBW issued on 16/12/2024, man. A local bail, man.
Item 56, Lordship, enroll has been issued on 26/3/25, but the order sheet, the ABL appeal reflected is wrong. The ABL appeal is 573/2019.
Okay. 2019.
19, Lordship.
Okay. And hey, 25/8/2020. Bail, huh? 25/8/2020. Bail and MBW or 26/3/2020. Yes.
Probably.
58.
Yeah, please, Your Lordship. Well, here I'm challenging the arbitrary action of the police for non-arresting of the husband of the petitioner, Your Lordship. Although several NBW has been issued against him. Your Lordship, the fact of the case is on 17/11/2022, the wife was awarded a maintenance for 5,000 per month, Your Lordship. Thereafter, Your Lordship, the wife has filed an execution under section 128, Your Lordship. After that, several NBW has been issued against the husband, Your
Where is
Lordship.
that NBW order?
The first NBW was issued on 21/10/2024. No action has been taken, Your Lordship. And second NBW issued on 18/11/2024
Where from you are getting those dates?
from the order sheet, Your Lordship, which is in Annexer 2, Your Lordship,
Annexer 2.
No, page 19.
page 19.
19, huh? Okay.
Page 19.
Okay. First was issued on 21/10.
Yes, Your Lordship.
Thereafter
18/11/2024. And the third was on 17/12/2024. Thereafter, no action has been taken by the opposite
Thereafter
party.
on 17/1/2025.
Which police station? Which police station?
That is police station.
Which police? You have
Banguri
Bangiri
Posi Police Station, Your Lordship.
Bangro Posi.
Yes, Your Lordship.
Bangro. Zero. Petitioner had initiated an execution proceeding against the opposite, against no opposite party. Okay. No, petition. Where is the maintenance order?
Police
Where is the
station has been implemented.
1 minute. Maintenance order.
I have only annexed the execution miss case number 335 of 2023, which is in page number 11.
This is the order.
Maintenance.
Sought to be executed. Which is the order? Tell me the date.
That is on Your
Is
Lordship.
it under DV Act you got?
Yes, Your Lord. Domestic violence.
Then
I have
page
filed.
23.
Page 23.
Petitioner initiated and DV case number nothing PMC. DV case petitioner initiated a DV case against her husband being CMC number 145 of 29. By the order dated, which order?
17/10/2022, Your Lordship.
By the order dated 17/10/2022, the SDJM Baripada
Yes, Your Lordship.
directed the advocate of the petitioner to pay the maintenance at the rate of 5,000?
Yes, Your Lordship.
5,000 per month. 5,000 per month. The advocate of the petitioner has not paid the maintenance. Therefore, she initiated an execution proceeding before the court of Which court? You put court of,
SDGM, your lordship.
SDGM
Mayurbhanj,
Baripada
Mayurbhanj, Baripada.
as execution petition number
CMC number 335/2023.
335/2023.
5/2023.
CMC number 335 of 2023. The SDGM Baripada, by order dated first order 19th, first order by order dated 21/10/2024, issued NBW against the husband of the petitioner. The same has not been executed. Therefore, on 18/11/2024 and 17/12/2024, the NBW order has been reiterated. However, these NBW has not yet been executed. Therefore, the petitioner is aggrieved and has filed the present petition in any the IIC Bongri Police Station for as a respondent. The petitioners, responsible for the petitioner submits that it is the duty of the opposite party number 2 to execute the NBW issued by the competent court of law. The prayer made by the petitioner is valid, and since the NBW has already been issued by a court of competent jurisdiction in the execution period, it is duty of the opposite party to ensure the execution. Therefore, the opposite party is directed to be well that the date from suspense is executed as is possible month.
Pledge to lordship.
Yes.
59.
Yes.
59.
Possible.
60.
Yes.
Last occasion,
Yes.
and referring document, I have already filed the in additional application.
Yes. Yes.
And the commissioner has passed an order that this is not a private temple institution. It has been declared as public temple by the commissioner.
Yes.
And this order has not yet been challenged. That remains unchallenged as it. This fact, this document was not filed in the inspection, and I could not get any scope to show this document at the time of admission because this was disposed of at the time of
Which
admission.
document you have?
And,
This is Annex 3 to the
So 3 for
additional affidavit.
additional.
Yes. Yes, sir.
Well, that is there in the order, that particular document, in the order which is under challenge. The short dispute is, my lord, under the old act, it has been decided it's an accepted temple. The second order, accepted temples means with heritage temple with heritage trustee. That order was passed in 1951. After that, 42 proceedings were initiated by the department, also by the villagers,
Yes.
which has been confirmed. Now 27 is only an administrative order. 27 starts where there is no heritage trustee, non-heritage trustee has been appointed. So on this honorable court has held, when there is a judicial declaration by the commissioner that it is heritage trustee, you cannot pass an order under section 27 that interpreting that order. You don't, that can be done in appeal or by a separate 41. My lord may see the order under challenge.
Yes.
That is the main thing, whether there is an error apparent on the face of the record. My lord may see that order. It was not done in first.
Page 10.
Yes, page 10, your lordship may kindly see. Your lordship may come to the second paragraph. Pursuant to the aforesaid order passed by the additional assistant commissioner, what has happened, my lord, he has filed a petition before this honorable court stating that my application under section 27 is pending, which may be disposed of. That 27 proceeding is misconceived because already a judicial declaration is there, it is heritage trustee. So that should not have been entailed. Now, my lord may see what is the order. Second part, pursuant to the order passed by this court, the additional assistant commissioner of endowments temple is an accepted temple. Accepted, I have the old act, temple with with head rate trustee, having the head rate trustee, this fact has already been determined much earlier under the OHRE Act 1939. The parties filed different documents in support of that.
Where are you reading?
My lords,
You are reading where?
page 10, last paragraph, I start.
Yes, yes.
Pursuant to the aforesaid order passed, the Additional Assistant Commissioner Cuttack so and so issued notice to the parties. And at the next page, temple is an accepted temple having head rate trustees. And this fact has already been determined much earlier under the OHRE Act 1939. The parties filed different documents in support of their contentions. By the impugned order, the Additional Assistant Commissioner of Endowments has come to a finding that the institution is a public temple and the ancestors of the person in management were not the founder of the temple in OA number so and so, and no binding effect on general public and the endowment department, and that current person in management is not the non-hereditary trustee of the temple. On the above finding, the Additional Assistant Commissioner of Endowment submitted a report to the commissioner to index the institution as a temple with no hereditary trustee.
Yes.
During the course of hearing is submitted by land counsel for the petitioner that disregarding the effect of different earlier orders passed by the endowment authorities in respect of the institution concerned, and to give a finding that the institution is a public temple without head trustee would have been given section 41 of the OHRE Act.
Yes.
Previously, that was by the commissioner.
Not under 27.
Yes, and not under section 27. Land counsel for the OPs do not dispute this proposition. Mr. Sakshi Das, senior advocate, has appeared.
Yes.
It is however submitted by Mr. Das and senior counsel appearing for OP numbers 1 to 7. The opposite parties could still initiate a proceeding on section 41 of the Act, which there is no bar. Next page. The counsel for the petitioner does not dispute that a proceeding on section 31 can be instituted, and all questions, including the questions of res judicata, can be raised in the said proceeding.
Yes.
In this aforesaid submission, the order dated so and so by the National Commissioner, it is directed in the event of any proceeding on section 41 of the Act is filed in respect to the institution, the same shall be considered by the Additional Assistant Commissioner to own merit and dispose of in accordance with law.
Yes.
There must be some infirmity in the impugned order.
What is wrong in it?
Yes, I'm committing.
Yes.
While passing the order,
You say that the Annexure 3 order could not be placed before court.
yes,
Had it been placed before court, the order would have been different. But that's not the case. Case is the court is alive to the fact that there are many orders.
there are many orders.
But despite that, the court says that you resort to 41.
Yes.
You resort to 41.
Yes.
What is wrong in it?
Section 6 of the old Act.
I am not going to adjudicate the matter afresh.
That is equal to
It is a review petition.
Nobody.
You are aggrieved. You go and tell the right court. What is the error apparent on record?
Error is that
You said that one of the order which you have now filed as Annexure 3, this was there with you, which could not be pointed out to the court.
Yes.
Therefore, had it been pointed out to the court, the scenario would have been different.
Another point is
At this point, let us then we'll research at this point. This point goes.
no, not those. Annexure 1 doesn't stand if it will remain operative.
Let us
Annexure
see.
1 doesn't.
What is the tenure of this order? Let us see. Annexure 3. Additional affidavit. Yes.
Annexure 3. The said institution has been already declared as a temple.
That you, when the 41 proceeding will be initiated, go and register all these things there. Your door is not shut for all times to come. 41 proceeding will be initiated, then you agitate all these issues there.
My lord,
That's what the court says that.
my lord,
It is open now.
yes, my lord, in the impugned order, my lord, challenged by the in the writ petition. What is the infirmity in that order? He has analyzed.
I'm not going to go into the infirmity part because this is a review jurisdiction. Infirmity may be there, may be absolutely wrong. I'm not here to correct that. I have only to see whether there is an apparent error or not.
Yes.
You said that there was an order
and
available which could not be placed before court.
Yes. That is
Had it before court, the scenario would have been different.
Yes.
So therefore, order 47 covers your ground. But so be the order. That order is neither here nor there.
That's it.
So better you should bring this to the 41 court.
Yes, that is exact. That is the submission of both sides there.
Both sides.
Senior counsel
I think
appeared. Now you are moving the review. That is also, he is not the original counsel also. Writ appeal dismissed, Supreme Court dismissed, and telling that I will file a review petition. No liberty. You will Supreme Court SLP dismissed, telling that yes.
Not liberty, no liberty. Annex 2, your lordship, no liberty has been granted to me.
Therefore, I'm hearing you.
Then that is-
Otherwise, I would have dismissed by now.
So that is the thing. 27 is an administrative proceeding which he cannot decide the judicial thing. That is the short point.
Yes.
He is
What
missing the
Supreme Court has said that you file a review petition. You file a review petition. You have to make out a case of review. You have to make out a case of review. Does it say that it's a case of review? You won't file it. It doesn't say that.
Yes.
No,
It
why-
says that you have a liberty to move a review petition
No,
You-
while passing
and satisfy the review court.
While passing the order, the impugned order must be some, the honorable court must have found some infirmity in the order.
I don't know, Mr. Find or not. I don't know.
No, that has not been discussed in the order. What is the infirmity? What is the infirmity in that order?
Which court has not decided?
My lord, this honorable court has not discussed the infirmity part.
This court only says that by 27 is not applicable, 41 is applicable, file a 41 petition.
Yes.
That's all.
My lord, the
And
finding-
everything will be decided there.
And he has given some findings that will be annulled in one petition.
What finding? He has not said anything. What finding? Nothing.
Discussed many things, my lord, and he said.
What many things? You show me what he has discussed. What has he
Reading out 7. The impugned order starts from 76, my lord. 70.
70?
Annex of 16, which has been added.
Annexure 16 to?
Impugned in the writ petition, Annex of 16.
Yes.
And 78, page 78. Can you see page 78?
78?
And
Yes.
I have heard all the parties, verified the documents, the old records were called for from the record room. There are 2 cases filed in respect of the nature and management of the above institution. The first being OA number 24 of 47, which are filed in the additional affidavit. This is Yudhishthira Das, the elder brother of the petitioner, writ petitioner, to declare the institution as their private one. The second case being OA number so and so was filed by Sri Udayanatha Das to declare the institution as the private one. While perusing the case record in 1946-47, it is found that after the institution of the case, notice was duly published, and after hearing all the parties, the institution are declared as a temple as defined in subsection 13 of section 6 of the OHRE Act 1939. By the order dated 28.
Let's see what is this order. The order is passed in an application under section 27.
27.
Okay.
After the direction of the honorable court.
1 minute.
In another writ.
27, this application order was passed. The court says that 27 is not applicable. You have to file in 41.
Yes.
That's what the order is. You went up to Supreme Court. Supreme Court says that it's correct, but you say that I'll file a review. Go and file the review.
Yes.
You have filed the review. What is wrong in it, that order? Where is the question of reopening it? What the court only says that 27 order is not maintainable. You have to file a 41 proceeding.
Exactly.
And the lawyer who is appearing is conceded to this position. It is basically a consent order in true sense. Just see the learned senior counsel who was appearing, what has he said?
First, it's that I in the review petition paragraph 11 to 14.
No, let us come.
Paragraph 11 to
See,
14.
learned counsel for the opposite party do not dispute this proposition. It is, however, submitted by Mr. Das, learned senior counsel, that appearing for opposite party so the opposite party could still initiate a proceeding under
Yes.
41
Yes.
of the Act.
Yes.
This is the position.
Yes.
And the finding of the court is here, the preceding paragraph. Just see, during the course of hearing, it is submitted that the learned counsel for the petitioner that disregarding the effect of different earlier orders, including the order which you are now citing, earlier orders passed by the endowment authority in respect of the institution concerned, to give the finding that the institution is a public temple without hereditary trustee could have been given only under section 41 of the Act,
Exactly.
but not under 27.
Yes.
And this position is, given consent by both of you, this position of law.
Yes.
No, initiate 41.
Whatever.
Initiate 41. Yes. Yes. What is here?
See one,
Okay.
Yes. For this case, Person Lordship Direction, I have filed an amendment petition. And that amendment petition, during pendency of that, the authority has already changed. So another amendment petition could have filed. That in place of the previous amendment petition, the amendment petition will be accepted that, but this the authority already changed, that post has been changed. That is a permitted to file another amendment petition for issue of notice to the authority. But it's matter relating to release of some errors. That is already sanctioned, but that is not been given to him, even after retirement. Now he is a 75 years old man. So during pendency of the case, the previous lawyer died. He informed the petition. That is a matter again dismissed. So subsequent, I have been engaged.
Now notice has been issued.
But the amendment petition which I have filed earlier, that's the authority already changed. So another amendment I have to.
Day is filing.
So I have another, otherwise notice will be introduced that will go there.
Why these matters are pending, I don't understand.
The previous lawyer died, that I engaged that.
See, this is pending since
2011. Annexure 6 is declared that sanction money has been sanctioned to in favor of the.
I am not on
Yes,
only
yes, okay.
dismiss in default.
The limitation is.
Notice was issued, what, how much delay?
67 days.
Huh?
67 days.
I will condone the delay, restore it, let it be heard unnecessary.
Yes, also, otherwise the government is there, the other side of the copy.
Otherwise, this will keep on,
All right, but 2011 matter, year-old matter.
11 matter.
2011.
2011 matter.
So it's my client is in a dying condition now. 2,48,000, 88,000 is not given even after retirement.
Who are the opposite parties?
The other governments.
I will condone the delay and restore it. For the reasons stated in the application, IA number so or the delay of how much delay? 67 days. 67 days is condoned. And the order dated, which is the order dismissing the writ petition. Order dated.
अठारह 6/2018 6/2018 18/6/2018
is recalled. The writ petition number 23229.
Yes.
Of 2011 is restored to its original file and leaves the writ petition before the assigned bench for final issue. Go and argue whatever.
Yes,
discuss. 62.
Well, sir, copy of Mr. Jana is present today.
My lord, I am appearing for option number 3, but the brief was given by a lawyer who has already passed away in the meantime, but I have no contact with the client, so I hope for issuance of notice to the option number 3.
What I suggest, Miller, on that date also, your Lordship had suggested that both by notice and also to serve like the lawyers. Now, notice also allow us to take a notice by speed post so that your Lordship can fix up a date so that matter can be disposed of. Otherwise, the matter is very simple. Question is whether the father is entitled to get in terms of the Succession Act, father and mother, or the nominee's father will get it. That is the only question. You also have seen that section 15.
You don't have any instruction now.
No.
Are you in contact with your client?
No, my lord, because my associate, Mr. Party, has brought this case, but it was also given by a lawyer. So we have no direct contact with the client.
So you are presently not in contact.
Not in contact.
Legal position, my friend can say.
So let you try and
We can take notice by speed post. We in Jamshedpur, we take notice by speed post. You also fix up a date, returnable date, so that matter can be.
On 2/4/2025, this court directed granted liberty to the petitioner to serve this proceeding of this court to Mr. R.C. Janna and Mr. R. Padi, and counsel appearing for the party number 3. Mr. Janna appears today and submits that he has no contact with the party number 3. Hence, a fresh notice is to be issued to party number 3. petitioner may take steps to serve opposite party through speed court. The speed court leaves the matter for final disposal on 25th. It is small matter. In the meantime, if you can contact, contact and come.
I also-
The legal issue, we can dispose it up.
I also write letter to.
You please write a letter,
Mine.
Mr. Janna. Because till today, are you holding the Wakalatnama? No.
Yes.
Buklatnama is there, my lord.
Then, it is your responsibility. I'll record your presence and decide it then. No.
My lord, this is the.
Janna also submits that he would contact the opposite party number 3. I need not wait for opposite party number to come, just for.
So I am 3, my lord, not 2. I am 3.
3, okay, yes, 3. You contact, otherwise you please come on that day, we'll dispose it out. Because these are legal issues.
Completely legal.
God bless.
May I please your lordship? It says state review, my lords, delay of 2,411 days. The husband dated
2000?
Before
411 days.
Senior, let me finish my case, your lordship, first. What happened? Here is a case. First,
you come to the delay.
Yeah, lordship, that's right. I'm going to definitely come to the lordship, and I will definitely satisfied regarding the part of the delay, lordship. Therefore, before going to the part of the delay, lordship, the facts of the case is very necessary. You have to argue the delay part, lordship. What happened? Some of the employees of the lordship, that is your lordship, both the power cooperative society employees approached before this honorable court regarding some dues regarding the VRS dues, your lordship. In that writ application, both the cooperative society, the CDT is not matter, therefore I am not going to that part, your lordship, now. In that writ application, is the Bautic Super Cooperative Society is implemented the opposite part number 4. At that point of time, the honorable court is directed to delete the first, because there is the society act that is writ is not maintainable, suit is maintainable. However, in that matter, lordship, the society is deleted. In that case, in that writ application, the state has filed the counter. The counter categorically refused that the writ application not maintainable, and the dues or whatever the dues already been released by the society towards the employees. However, the coordinate bench at that point of time given certain direction, lordship, that part, your lordship, and place in my lordship, that writ application, that order was 12367, judgment dated 16/12/2011. The honorable bench is directed certain 3 directions, lordship. In 3 directions, there is no such clear-cut direction regarding release of the dues, lordship. Only directed to the employees to approach the authority by filing representation, and the states are representation consider the same. However, in that writ application, the society is already been deleted. In the meantime, the employees of the society approached the society. Actually, the society filed a review application in the year of 2012, lordship, before the review application 12 or 2022, lordship.
Against the order dated 16/12/2011.
Yes. In review application, the honorable court in very orders passed in a cryptic manner, lordship, the category directed all the responsible, lordship, that I am reading 4 lines from paragraph the impugn order. It is clear that no way the present review petition has been saddled with any liability. The ultimate liability on the state has been.
What do you want to say on this?
My responsibility. Then that application dismissed. I have also approved the honorable appeals court against that order. And honorable appeals court, on my request, the SLP was dismissed on the ground the review application filed by the society before pending for the honorable this court, your lordship. After the review application filed by the society was dismissed, therefore I might file the present review application is filed. There is a delay, and there is sufficient cause for filing the review in delay. I have given in my limitation petition option. And this case is lordship dead chart to lordship for better clarity of the lordship to how the delay has been caused. This delay has been caused in filing the review application, lordship. And
what happened to the order pass in the review filed by him? Have you challenged that order? No. Have you challenged that?
No, we lost it.
That is, option is there to challenge. Why don't you challenge that order?
That I am not challenging.
Then you didn't challenge the order. Now you become wiser to file another review against the principal order.
Yes, but on the ground, after society files.
Your case is on 16th, what is that date?
16/12/11.
16th 11, 2020, 2011. A judgment was passed.
Yes, sir.
Okay, judgment was passed. You challenge that judgment before Supreme Court. Okay. By that time, the society filed a review petition against the same order. Supreme Court did not interfere, saying that since review is pending, you go there. Okay.
Yes, sir.
You came here, contested that review filed by him.
No.
Whatever. Okay, okay, it's all right. The review is dismissed. Whatever. Against that review order, you could have gone to Supreme Court. You didn't go. You prefer again another review petition against the principal order.
May please, Your Lordship.
How can it be?
Clarify, Your Lordship. My Lordship, we have gone to the Supreme Court in the year 2014 by filing itself.
That was also delayed.
Delay.
2011 order, you were going in 2014. Anyway.
That part also taken in the.
Where is that Supreme Court order?
Page 28, let's see. Page 28.
1 minute. Supreme Court order.
Yes, page 28.
Annexure 2, page 28. Here, my Lordship, kindly have a glance. That's
20.
17/11/2024.
1 minute, let me see that.
Annexure
20.
8, let's see.
17/11/2014.
8.
28, page number 20.
Let us go slow.
Yes.
20.
8, let's see.
Before that, application for delay in the filing.
Where is that order?
Annexure 2, let's see.
Annexure 2, my Lordship.
2.
Of the review. They have given us.
Annexure 2, my Lordship, page number 28.
State made a submission that a review is pending. Therefore, my lord, the Honorable Apex Court,
My
in view
Lordship,
of that submission, and
without our knowledge, they have filed, the liquidator, authorized liquidator had filed the review application in the year 2012. We have come to the Supreme Court in the year 2014. When we come to know that the review is pending, then the Supreme Court dismissed the review application, application. Then in the review, my Lordship, we are not the party to the review or nothing, my Lordship. In the review application, my Lordship, kindly have a glance, page number 34, my Lordship.
34 of?
Review application,
Yes.
annexure 3, my Lordship.
Yes.
In the year 2019, on 27/2/2019, what the Honorable Court, my Lordship, have viewed that this review petition has been filed by the review petitioner on the ground that he was initially arranged as opposite party number 4 in the writ petition, but his name was deleted subsequently at the death of the writ. Then it is now submitted by the learned counsel for the review petitioner that as the entire liability is saddled on the review petitioner to pay the writ petitioners and he was debarred from the contesting the case is aggrieved by the impugned order. Then from paragraph 5 of the impugned order, it is clear that no way the present review petitioner, where the court clarified that review petitioner has the saddle with any liability and ultimate liability on the state has been saddled to protect the interest of the writ petitioners. For that, my Lordship, we have filed this review petition. When the liability come to us, my Lordship, then we file the review petition in the year 2019.
Then you have a vast case. Because your SLP against the main order has already been dismissed.
Because of the review is pending, my Lordship.
Where does it say? It is only dismissed. I have read it. Because you made a statement that review is pending.
The learned counsel for the petitioner submit that the review petition against the impugned order is pending before the High Court.
Thereafter read it.
In view of the above, the special petition is dismissed.
Then you have not pressed your petition there.
No, my Lord, because
A person who has no right has filed a review petition thinking that liability will come to me. The court says that the liability is not the state's liability. Then your case is worse now.
Going to the lordship review, lordship kindly hold me basis what direction. Only direction to constitute representation by filing individual. There is 49 petition of lordship there. There is no clear direction, and in that with the application, is the OP4 is a private society and the suit is not a therefore at that point of time on the risk of the prayer petitioner, the OP4 is deleted. Therefore, the honorable bench directed to
See,
counsel.
this review petition is dismissed on 27/2/2019.
Yes, sir.
When you filed the review petition?
Review was
Thereafter.
filed in,
Thereafter.
1 minute. Obviously thereafter.
22/8.
2019.
22? 22?
2019.
August 2019. February, then August. How will you explain that delay? Okay, forget about that part. I will give you the benefit of the delay because of the pendency of review.
Yes,
How will you explain that delay?
In my IA application, I clearly mentioned that after this is not the review.
Then 6 month delay.
Society,
6 month delay, how will you explain? Forget about 8 years, whatever. 2011 to 2019, I will give the benefit, saying that because of the confusion of a review being pending there, you were pursuing. How will you explain the delay of 6 months?
Paragraph 6 kindly as per my limited petition, I clearly mentioned after receival of the 22
Very difficult for you to help. I can't help you.
I give the
And it's
details.
similar order,
So that
Lordship.
is convenient to
Lordship, kindly go through this order. Your Lordship.
1 minute. Let us see. What is the explanation?
Para 6 and 7.
The same thing.
Para 3 is also important, Lordship. Kindly go through para 3. Paragraph 3, Lordship. Lordship, kindly go to paragraph 3.
3.
Yes.
Yes.
They say, my lord, that WPC number was disposed of by the Honorable Court on 16/12/2011 as intimated by the Office of Learned Advocate General, Odisha, White letter number 638 dated 6/1/2012, received by the PE department on 16/1/2012. Dismissal of the writ petition was very much in the knowledge since even of argument it is on 16/1/2012. And the review is on 22/8/2019. And para
Is delay that would be satisfied. The pendency of the review and that is.
By the way, what was the direction?
Direction was, Lordship. Page 25, Lordship.
Paragraph 5. There is 3 directions.
Yes, come to page 4 of the order.
Yes, I am there.
Yes, regarding here to the all also.
Married to
Sir, pay within a 6 months from the date of. Yes.
One is first part is type 1 is admissible dues, my lord. Roman 2 is, my lord, balance amount of claim, my lords. Honorable Court is clear on this.
There are many matters pending.
No, this matter is separate, my lord, because those are the spinning wheel matters. But this is a power loom matter. This is about the power loom, my lord. This was not tagged with the spinning wheel matters.
What is the liability? Have you calculated?
No, ma'am.
How many employees are there?
40 employees.
40. What is the liability?
But I have no instructions.
Get the liability. What is it?
And Lordship, can you go through it? I have gone through it. Similar order of Lordship, Lordship, but delay is concerned.
That
Now that I know.
Lordship.
Postmaster General will bring. They are in difficulty, but let us see what is the liability. Now the question is the liability of that society or the liability of the state.
Yes.
Society said that you are not liable. He happily went up. Now state's liability.
Yes.
But the problem is
Another so far suit as mentioned by my learned friend is concerned. There is no pleading of civil nature or suit in the because I was conducting this writ petition. This suit or this civil liability is not.
I am not going on that. I just want to know what is the liability. Its liability is very huge, then I will think of what to do it. If its not liability is very limited, so why should I interfere? In the ground of delay, I will dismiss. The liability may not be how much the liability would be. 40 people are. What is the liability according to you?
It will be around 1 crore somewhat.
Then I will not interfere.
1 crore.
If it is hundreds of crores, then I can interfere. For a state, 1 crore, 2 crores is nothing.
41 employees.
Ideal employers.
They pay either you pay or the
Counter, I specifically
You tell me what is the amount, exact amount.
Let them file an affidavit, my lords. What is the claim?
Exact amount. Oh, you tell me if the liability is very less, on the ground of delay, I'll dismiss, at least these people will get something. And everybody will get a couple of lakhs.
Yes,
5,
no,
6
there
lakh
are
will
also, workers are also there. My lords, it will come around 1 crore or some.
One more thing is that as per the direction of the order part basis, whether they have approached the authority by filing representation and dues, categorically mentioned that.
These are the things not in the review, my lords. In the SLP,
That they will do it after dismissal. They will do it. Why do you worry?
Yes.
let him file an affidavit or whatever.
They will do it, but you calculate the. I will put it on 21st.
This much approximate.
No. You do it. I have read it. It is so complicated a thing. I have made up my mind.
Get to us.
Assignment of Hon'Ble Justice R.K. Patnaik. So withdrawal. Matter was in the list, but after it has been list.
Withdrawal, you can wait month.
CMP, the limitation will come because it should have been RSA, second appeal. Instead, it has been filed as
Section 14, where will it go?
Section 14 is there. There is also a stay required.
Section 14 you will forget.
Eviction matter the 14 is gala वालों JAL limitation and notice you 15? 15 if you lock this 15, yes, 15 for
My lord, I am pardon to mention before your lordship today's list item number 103. My lordship, it is the noting that LCR barcode was which paper?
I am for 100.
Which paper book? But paper book I have not received. I have contacted today.
You have paper book.
So that let it come 12th, we commencing 12th of May, so that I will get prepared because this is a appeal against a conviction. It requires thorough preparation, and I have not yet received the paper. Only
Office is directed to supply the paper book to the counsel for the appellant as well as vigilance force. He'll fix it.
Item 66. Item 66.
Now, wait 1 minute. He will after he will adjust and give it. And if under the pressure he gives the date and the matters are not reaching. Wait, let him adjust the list and yeah.
Item 66.
Please wait and he will.
Item 66. I have already filed the requisite.
Already filed?
Requisite.
After taking stay, obviously we will file.
Confusion process.
Process in requisite.
Confusion
Process P is the requisite.
I already filed. So I pray that may be accepted and.
If there would not have been stay, then there would not have been any confusion. Because of the stay, this confusion comes. I know that. Okay.
Lordship 69 to 70. Lordship 69 to 70.
That the interim order is only creating problem in your office. Your junior and everybody is getting confused. Interim order to cancel.
Lordship 69 to 72 extension of time.
69
to 72.
Extension of time. I'll 69 to 71. 72. Extension for what?
Extension of time. Surrender
Cordial 30th for the last final opportunity. No further extensions are being given. Okay. Yes. Yes.
What compromise content is there? Item 18.
I'll take the compromise.
Item 26.
Yes.
My friend is for the paper, I am the opposition.
Yes. Charge sheet filed.
Yes. The
Where is
joint
the charge-
affidavit, the joint affidavit, I filed the charge sheet as well as order of cognizance. In the joint affidavit.
File
My
form,
lord.
you filed it. 376 and only.
Yes, 376 and 506. The cognizance has been also.
What is the terms of settlement?
My lord?
Terms of settlement.
Terms of settlement, the friendship has already been restored. Both are friends. So already they have restored their friendships. So on
Yes,
this, yes,
Who is this?
both of them.
Who is victim? Victim, what is the name?
Soumya.
Soumya. Okay.
Soumya? Well, Soumya, all for the
79.
My compromise matter I am taking you first, yes.
May
80?
80. Both they have got married. The victim lady, who is the wife of the present petitioner, she has appeared along with her parents. Now I am filing the affidavit on behalf of the parents and some joint affidavit. They were living happily. They were blessed with the children.
Where is the FIR? Where is the charge sheet? Nothing is filed.
That has been filed later on.
Where is that?
Cognizance order, I am challenging the cognizance order. I have also annexed the 164 statement. Everything, my lord, I have. Copy of the charge sheet along with 164, my lord.
2015, the FIR.
Well,
Charge sheet filed on?
charge sheet filed on 16.
And what is the stage?
That is still pending.
No, pending, but what is the stage?
Nothing, my lord. They have not taken any steps because the case has been stayed by the Sonoko for that.
Evidence has not.
No, not. And
charge has been paid.
No.
Charge is not.
No, not.
And
because they have got married and living happily for that reason. They are both are maintaining their happy conjugal life. Law of affairs, 164 statement is there. That father law of affair. On last occasion, your lordship directed to.
What is the age of this girl?
19 years.
Now.
Now, Oblique 29.
Huh?
Now 29. 29, 30.
She is married with the
boy. Present petitioner. Accused. And they are blessed with the children. They were living happy conjugal, maintaining their happy conjugal life.
It is at the instance of who is the opposite party number 2?
Two victim lady.
Who is the informant?
Informant father. Father is there.
Father, she is not implicated.
She has also shown affidavit that I do not want to proceed.
Where is the affidavit of father?
Father, by the
Okay, I am holding.
and joint affidavit.
In instance of the father of the opposite party on 9/7/2015 for alleged 2015. After investigations, the charge sheet in the present case has been filed. Where is the charge sheet? Where is the charge sheet?
That is page, my lord. 10 of my brief. Annexure 1.
10.
10. First page is 10.
This is charge sheet or FIR?
Charge sheet, my lord. Charge sheet, my lord.
On 2/7/2016. See, for alleged commission of offence under section 363, 376, 506, IPC, within section 6 of POCSO Act. The charge sheet, the charges has not yet been framed. At this stage, if his parties have settled the dispute, on the basis of settlement terms, the present petition will file. This the present petition. When have you filed the present petition? Where is the stay? Where is there? Was there any stay?
Stay was there.
Present petition has been filed. The petitioner and opposite party number 2, as well as the father of opposite party number 2, are presenting the court. They are being represented by their respective counsel. The petitioner and opposite party number 2 has now married on. When have they married? Where is the victim's affidavit?
Joint affidavit is there. I have under joint affidavit.
Where have you said that you married when?
That I have. Paragraph 2. Our other initiated the case, the petitioner, but now we are living as a husband and wife. We have been blessed with children and maintaining a happy conjugal life.
When have they married?
They have got married, my lord.
What kind of affidavit is this?
My lord, I have stated so. Birth certificate is there. They have got married, my lord.
Have they married or not?
They have married.
You tell me the date.
You just follow on the same.
No, you give me the date.
That is, my lord.
What kind of affidavit is this? They are living wife and husband. You want a approval of the High Court?
February 26 February 2015.
Marriage where particularly give me.
That is, they have married before, my lord.
Why should I accept this affidavit?
Before the village deity.
Living as wife and husband, therefore you pass it.
No, my lord. She has narrated that before the village deity.
Where have you said that in the petition, date of marriage, when you get married and when the children are born? Date. File a better affidavit. You can't take a seal of approval from the High Court like this.
No, my lord.
If they are not legally married, how can I pass it?
They have legally married, my lord. That is, I have made.
Where have you said that? In the affidavit, just see what have you written.
Just now I'm correcting that. I'm finding.
See, this is
So sorry,
not
my
done.
lord. Sorry, because they have appeared.
See, you are spoiling the life of C. Tomorrow she'll say that I'm not married.
No, they have. She has showed, my lord, she has appeared.
How can you get the seal of approval of this kind of affidavit saying that they are living as a wife and husband? You should say that on such and such day they got married.
Right.
They are blessed with a child on such and such day.
Now, in 26 February 2016, before the village deity.
I will take it up at now. Get the affidavit once again.
Just pass it over.
Yes. Give exact date when they married and where they married.
They have got married.
Is it registered marriage or marriage
Before the date now.
whatever. And thereafter when okay. Yes. No, call the list now. Password item 21. Yes. Password 21. Who is asking? Call the 21.
People district file. Taken up to Monday or Tuesday, already. Okay.
Put it after one.
23.
Yes.
The allegation is in Annex 7, page 50.
I told you in the
Yes, Lordship.
before lunch that you tell me the fact.
Yes, Lordship.
Yes.
In the fact is alleged that the accused person, Saroj Sethi and others forcibly entered into the plot of the complainant, abused in obscene languages, outright modesty of the complainant's wife, took away cash and gold ornaments from his house, and criminally intimidated them in furtherance of common intention. That's
Yes.
the basic allegation, Your Lordship.
Yes. Then what happened?
Your Lordship, now we have come to a settlement and we have filed a joint affidavit that is at flag B, Your Lordship.
The parties are here.
Yes, madam. I am appearing for the informant.
No, what about the accused persons are here? Today?
Not in person, Lordship, but they have filed the.
No, accused persons have to come and the opposite party has also to come.
Kindly, madam.
Okay. When do you want? You tell me.
Any day, Your Lordship.
You tell when, we can put it on 22nd?
Your Lordship.
22nd. Bring them, I will pass it.
Yes, madam.
Okay. 22nd.
Obliged.
24 also said.
Your Lordship, in item 24, there is a similar matter.
Similar or same?
Similar, Your Lordship. Your Lordship, in item 23 charge sheet, I am filing the charge sheet, Your Lordship.
No, in 24, who is the complainant?
Complainant is
Informant is the mother is in 24 item and 23 is his son.
Achha, see. Arising out of the same incident.
Same incident.
Okay. 24 we same okay. Yes.
27.
Pardon, Your Lordship, I will be allowed to file a.
File it. File it.
Okay, Lord. Oblige, Your Lordship.
Yes, 27.
Yes, my lord. Listener, my lord, challenge order of cognizance, my lord.
Yes.
That is 2994, my lord. Taken by the special judge, my lord, in NDPS case. Though the huge quantity of ganja recovered, my lord, but in fact, my lord, my submission before a small point, my lord, the charge sheet, my lord, the petition was arrested on my lord 2/4/2023 on the date of occurrence, my lord. Basically, on the petitioner confession statement, also confession statement, my lord. Charge sheet is submitted on 27/9/2023 within the period, my lord. 27/9/2023. Thereafter, my lord, this is the important, my lord. Cognizance taken on 29/1/24, my lord. During that period, my lord, the special court can't remand the accused to the custody since statute are submitted under section, my lord, 27/9/23, my lord. He waited, my lord, near about, my lord, 4 months to take cognizance, my lord, only because she reported not there, my lord. And can see order dated, my lord. That is, my lord, my submission, my lord, since accused in custody, the special judge can't remand the accused since statute are submitted within the period, my lord. He waited for C report about 4 months
To take cognizance.
That is, my lord, the bad in law, my lord. That is the applicable
Quantity
Forget about the quantity. What he says is, within time the charge, but the court waited for about 1 month.
4 months.
4 months to take cognizance, waiting for the C report. The Supreme Court in that matter, which is Mohammed Arwaz, it says that without C report, it is not the charge sheet in the eyes of law. In NDPS case.
Actually, now 2 to 4 are absconded.
You are bringing other issue.
Yes.
You address this issue. What is raising? What is your answer to that?
Yes, no. I have to take.
Issue notice. Notice. Already notice has been issued. No, notice was not issue notice. Call for the CD. Call for CD. We'll see.
Small quantity.
So why have you not moved application under 167(2), saying that there was no charge sheet?
The direct bail price. Lower court, my lord, they have no knowledge.
Still in custody.
He's in custody, my lord.
Oh.
For that is my lord. He can't remand it the accused, my lord. No statute submitted, my lord. 309 is the operating, my lord. Don't update the statute submitted.
Now the problem is now EC report has come on record.
Mom, I have not been paid, my lord. See.
So therefore, see, today even if I will tell you, go and file move application, because of that report, you will not get the.
309 subsection 2 reads like no court can take cognizance of an offense.
No, that's right. You are right. Absolutely.
That is the law.
You are right. You have to deal with it. You have to deal with it, yes.
28.
Time, take time. Next.
What do you want? Adjournment, okay. Adjourn on the request, yes.
42. My lord. Yes, my lord, petition files application for passing out cognizance. What happened, my lord? The case were instituted against 4 of the accused persons. 2 of the accused persons failed the trial. They have been acquitted on the ground that none of the prosecution of the 6 witnesses examined. They have not supported the prosecution, they have declared hostile.
Yes.
But I have annexed the judgment, my lord. That is page 22, my lord.
22.
22. And relevant my lord 27, paragraph 5.
27, huh?
My lord. 27, paragraph 5. Prosecution in order to prove its case has given 6 witnesses. We told one is the informant come victim of this case. We told 2 to 6 are the other input. Another victim, namely Gurudev Kisan, could not be examined on behalf of the prosecution as he is dead. Examination of the witness declined by the prosecution on their examination could not be improved in this case prosecution in any manner. Prosecution also exhibited 2 documents while exhibit 1 and 2. On the other hand, defense not examined any witnesses on behalf. The defense counsel during course of some argument submitted that informant and injured have false imputed the accused person in this case. The informant of this case, who was examined P.W. 1, has not supported the prosecution case. It is released from the evidence of P.W. 3, 5, and 6 that the victim Gurudev Kisan is dead. The informant has not deposed anything against the accused persons regarding the alleged commission of offence. All the prosecution witnesses have not supported the prosecution story. Hence, on the above ground, the prayer for acquit the accused. On the other hand, analysis paragraph 7.
Come to page 19, 29.
29.
Oh. Second paragraph.
Second
All
paragraph.
the prosecution
Witnesses such as P.W. 2 to 6, to whom the prosecution has examined as a other independent witnesses of this case have deposed nothing in their respective evidence against the accused persons.
Against the
accused persons. So, kahar koinati.
You face the trial, they may say against you.
That fact, they all of
you
them
have been absconding. Then they may tell against you. How do you know today? They have not spoken against the other accused person. So therefore, how do you know?
They, even if they did nothing, they have not stated in their evidence.
NBW has been issued against you now.
That is
Surrender. Surrender and yes. Surrender and I'll fix the 6 months. 6 months. Okay. Petitioner. Total how many accused?
4 accused.
3 faced or the trial? 2 faced. 2 of you are
abscond.
You are for 1, huh? The other one will come subsequently. Okay. Petitioner is one of the accused in FIR number so and so. Jharsuguda CS case number 13 of 2017, filed on registered on 9/1/2007. Parallel the commission of offence under section 147, 148, 225, 149, IPC review section 3 of SC/ST POA. After the investigation, charge sheet was filed in the present case on 19/4/2007 against the 4 accused persons. 4 accused persons. The petitioner and other co-accused, namely, who is absconding?
Present petitioner to the one of the
And another accused, who is absconding? Now, tell the name.
Ekadisa Dilla, Bulu Dilla, and Buddhu Dilla have been declared as absconders.
Petitioner and
Dilla. Ekadisa Dilla.
And
Bulu Dilla.
Ekadisa Dilla.
This petitioner.
Ekadisa Dilla.
Myself, there are 5 accused persons.
5 accused. 5 accused. Who all are then absconding now?
Absconding, my lord, Ekadasi Dilla, Bulu Dilla,
And the present petition, madam. Budu boy.
Ekadashi Dilla, Budu Dilla, Budu Dilla, and Budu Dilla is this petitioner. Budu is this petitioner, and other two, Ekadashi and Bulu. That absconding. Absconding, yeah. The co-accused Bhagavatia Dilla and Vikas Dilla were apprehended and they were subjected to trial. And the trial for the present petitioner and other absconding accused persons have been split up. The additional sessions judge Dharsuguda in TR case number 3 of 2007 by its judgment dated 26/7/2023 recorded an acquittal in favor of the co-accused Bhagavati Dilla and Vikas Dilla. Relying upon the judgment of the additional sessions judge Jharsuguda dated 26/7/2023, the petitioner is seeking washing up the charge sheet against him. Against it. Mr. Ragada, the counsel for the petitioner has taken me to the findings recorded by the additional sessions judge Jharsuguda in TR case number so and so. And submit so and so. He submits that the prosecution immediately failed to establish the case, establish his case against the accused person who will face the trial. Therefore, subjecting the petitioner to trial on the strength of the weak evidence and the strength of those evidence will be a futile exercise. Will be a futile exercise. I have carefully gone through evidence recorded by the prosecution in so far as the accused those who were faced with trial is concerned. The trial court has meticulously dealt with the evidence and formed their opinion that the prosecution could not prove the case beyond all reasonable doubts, accordingly recorded in acquittal. The benefit of the acquittal order passed by the additional sessions as Jharsuguda in favor of the co-accused person shall not inure to the benefit of the petitioner because the prosecution has laid the evidence vis-a-vis the accused person to face the trial. Face the trial. It is inevitable that the petitioner being absconded that they face the trial, face the trial, and it is open for the prosecution to lead the evidence qua the present petitioner, and it is the petitioner or Mr. Ragada, on the instruction of his client, submits that his client would be appearing before the court, surrendering before the court on or before 30th of April 2025, and this of the remedy will go it is open for the petitioner to surrender and move bail application, and or all the points for the grant of bail, including the round of acquittal being recorded by the competent court in favor of the co-accused person. Since this present case is arising out of an FIR registered in the year 2007, it is expedient. It would be expedient that if the trial is concluded expeditiously, preferably within a period of 6 months, preferably within a period of 6 months. With this observation, the petition is disposed of. Yes.
Yes.
Nobody is there. None appears for the petitioner. In the interest of justice, adjourn.
64.
My lord, this interim application is filed to keep in evidence the NBW issued by the landed court below for non-payment of the interim award, interim maintenance by the petitioners.
Yes.
My lord, kindly peruse. This case was in this case, the landed court below issued the NBW on dated 13/3/2025. 13/3/2025 at page 11 of my miscase, your lord.
11.
11.
Yes.
My lord, kindly peruse the annexure 1, your lordship.
Yes.
Wherein annexure 1 at page, my lord, 18, your lordship, wherein the landed court below directed me to pay 12,000 rupees per interim maintenance of the petitioner. My lord, kindly peruse annexure 8 at page.
What happened to this order? This order has become final.
I have challenged the regarding the maintenance, about the maintenance, your lordship.
Yes.
Amount. My lord, kindly peruse this 78 page number, annexure 8, your lordship. Only one line, last below.
Yes.
You take,
in spite of all efforts,
admitted that that she is working at Vikas nursing home and getting rupees 12,000 per month. The statement was given by the opposite party number 1 before the conciliation officer, your lord, conciliation. Thereafter, your lordship, I filed, after issuing the notice, I filed some my income, regarding my income, monthly income, your lordship, and that was at page 47, your lordship. At
47.
47, your lordship. We specifically mentioned I have got 9,000 per PM and submitted some.
Yes.
IT.
Notice was issued?
Notice was issued on dated 18/12/2020. Thereafter, my lord, kindly peruse the property.
1 minute, service.
My lord, my lord.
Yes. Service.
Dipti Patnaik already he had appeared, but not submitted any document, your lordship.
Okay.
My lord, kindly peruse next page number 82.
Now, what are you seeking now?
My humble submission before lordship, though the landed court below, without going through all the applications, has issued the NBW against me. Even after, even I am ready to pay some.
I'll stay the NBW. Go and appear and argue all this point. Why are you? Stay the NBW.
My lord.
As simple as that.
My lord.
Yes. Where is that NBW order?
My lord.
Is a matrimonial dispute? Let him go and do what?
My lord.
Yes.
My lord.
Where is the order? Show me.
At page 11, your lordship, in
18, page 18.
Page 11, your lordship.
Where is the NBW order, sir?
NBW order. And the.
Show me NBW order.
At page 11, my lord. My miscase 75 of 2025.
11.
My lord.
Order dated?
13/3/2025.
Petitioner is agreed by the order dated
13/3/2025. And
well, page 11 is something else.
No, of my miscase, your lordship. Of my miscase 75.
Which miscase?
75 of 2000. At flag. I got the flag.
Mr. Ponda, what is your
My lord.
main petition?
Main petition, my lord. In my main petition, I elaborately by some clarify your lordship. I have no income at all. I have no income at all. But my wife, who is visited me.
No, you have in the main petition, you have challenged the order dated 30th August 2024.
Yes, your lord.
What is that order?
My lord, that order is my lord.
Yes.
At page, my lord.
Yes, 14, page 14. Come to that order.
Page
What is this?
Page 18, your lordship.
Yes.
Page 18.
Yes.
Order. The order portion, your lords. The petition for interim.
It starts from page 14 onwards. Read it. Yes.
The petition for maintenance filed by the petitioner is allowed. The OP is directed to pay sum of rupees 12,000 only per month to the petitioner for her sustenance as an interim maintenance from the date of this petition, that is 11/11/2022, till the final adjudication of the proceeding. The interim
What is happening to the final adjudication?
Till now, no evidence was led by the petitioner, opposite party number 2, your lords.
I will give a direction that the final petition be disposed of, and meanwhile NBW stay.
My lord.
Okay.
Yes, my lord. My lord.
NBW order, show me give me your file. Give me your file.
My lord.
Tell me where is that. Show me the
Plug E. Plug.
I don't see one that one.
Like E.
Petitioner is agreed by the order dated 30/8/2024 passed by the family judge Shambalpur in CM 39/2022, directing the petitioner to pay interim maintenance at the interim maintenance of 12,000 per month to the opposite party. This is 125 proceeding.
125%.
The proceeding initiated by opposite party under section 125 CRPC is pending for final disposal. And by way of the impugn order, only interim maintenance has been awarded. Mr. Panda, let me counsel for the petitioner. Taking me to various documents, submits that the opposite party is gainfully employed and getting salary of rupees 12,000 per month from which hospital?
Because nursing home.
Because nursing home.
And also hotel business, Sital Hotel.
He submits that apart from that, the income, apart from that, opposite party has other incomes as well. The without taking into consideration that aspect of the matter, has passed the order for interim maintenance. Pressing the interim maintenance, the respondent opposite party has filed the trial court. The NVW has been issued for non-compliance of the interim order. While order dated 13/3/2025. On the application by the opposite party in criminal execution miss case number 30 of 2024. Mr. Pondal and counsel for the petitioner further submit that is ready and willing to settle the dispute with the petitioner by paying the reasonable compensation. However, the trial court has not considered the material placed before it by him. Be that as it may, I am not inclined to entertain this petition at this stage. However, suffice it to say that the petitioner shall appear before the court on or before May on or before 5th May, 5th May 2025, and move application for variation of the interim order. It is expected that the trial court shall decide the application under section 125 CRPC on the basis of the law laid down by the Supreme Court in Neha versus Rajesh versus Neha, judgment versus Rajesh versus Neha. And therefore, in the, till the petitioner appears before the court on or before 5th of May, the NBW issued against him by the order dated 13/3/2025 by the Family Court Sambalpur in criminal execution list case number 30 of 2024 shall not be executed. With this observation, the petition is dismissed. You read Neha versus Rajesh versus Neha, on that basis you will decide. File the affidavit and it will be decided. Yes.
My lord.
Yes.
Urgent certificate copy.
Yes.
See, file.
I have for modification of the case certificate 10 lakhs. My IA page number 11.
What are you?
No, 10 lakhs they have fixed for during my bail. Now I am trying to reduce that amount to 1 lakh or other any property surety.
Notice was issued to opposite parties.
Sir, I have already sought the copy.
One copy will be and another copy is
Reliance, sir. I have already sought that copy, sir.
Sir, what is your grievance? You tell
My grievance is to modify the amounts of 10 lakhs.
Which order? Modification of which order?
2355/2009. Order.
Which page, sir?
Page number 11, sir. IA.
What is the main petition?
Main petition, sir, 2355 CRLMC.
What do you want there?
I want to, sir, modify that amount which was fixed by the CGM Bhubaneswar. Now the case is pending in CBI 1 under PMLA. Because so that I sought the copy.
Send the order written 9/9, 2009.
Yes.
The submission made above, this court directs the petition.
Which page? I am asking that.
11, sir. 3215 my IA, page number 11, sir.
Yes.
The CRMC 2355/2009.
Yes, what happened there?
That is, was last condition. In view of the submission made above, this court directs the petitioner to survey before the lawyer CTM, version and move for bail on or before 17/9/2009. In the opposite case, and in such event, the CTM shall admit the such for the petition as will be deemed just and proper research. The petitioner shall furnish the cash certificate of 10 lakhs. This you ask to modify.
Yes, sir.
That
I want to modify that 10 lakhs amount.
now the matter is in progress.
No,
He is to surrender by 27/9/2009. He has not surrendered yet. He has not.
You not
no, sir. I have surrendered. I have deposited that amount. Now I mean,
he already deposited that money. He wants it back. That's
No.
what you are saying.
No, I'm saying it won't, sir.
You are going in that direction. He is going in some other direction.
No, sir.
Please wait for 5 minutes. Let me read it and
Like the last occasion you have.
What is the main prayer? What is the main petition which you have filed?
Sir, I have filed 482 quashing for this FIR.
Yes. You are not pressing that?
Yes, sir, I am pressing that.
And you said now say that you are agreed by the order imposing.
That CGM already fixed their term and conditions, sir. First condition is 10 lakhs of security. That amount I am wanting to modify that.
Sir, it is not CGM, it is this court.
No, sir. I am the lower court has fixed. Then subsequently it has been transferred to vigilance, state vigilance.
Between 9/9/2009.
What he read it out is this court's order whereby 10 lakh rupees was directed to be furnished by you.
10 lakhs I have already deposited that amount, sir, during that bail.
Then you want a modification of this?
Yes,
court's order?
I want to modify that amount because he's already retired. This person
Which,
is
whether
my
this order, whether you are asking for modification of this court order?
Yes, sir.
Or-
Yes, my lord. I want the
Which order? You tell me. Which order? Dated?
this order 2355/9/2009.
That is
This order has been passed in 9/9/2009.
This order you.
Yeah, I want to modify that.
Condition number one, then.
One, sir, only one, sir. Whether the property security or reduce that amount to 10 lakhs to 1 lakhs or any other. I have already complied, sir. Now he is regularly attending the court, sir. No.
We have already compared this order.
Cash security you have already furnished.
Yes.
You want it back
I want to.
by substituting that.
Substitute property security.
What is there? See, this order was passed.
Already complied. There is no scope.
Already, maybe, why not scope? 9/9/2009, an order was passed by this court granting him bail with the condition that he will furnish cash security of 10 lakh rupees. He has furnished the cash security and participating in the trial. Now today he says that I need back that money, please substitute that property security. Why this condition? Condition is to ensure his presence in the trial court. He is doing it. Do you have any objection?
Objection in the sense that there is no such development. That for this reason,
The very fact that he is appearing before the court, why his money is. See, first of all, these conditions are onerous. First of all, even if it is there, he has come a bit late. That's a different story. But he is participating. If is it your case that he is not participating? His conduct speaks to you know. See, the bail is granted with a condition that he should appear. He is appearing.
Sir, property should I can spare my
I will answer
agriculture
that.
product, sir.
What about the main petition? You will not press?
No, sir, I have pressed at this time because I was not that time. I was an advocate in that. Disposal already.
I will, sir, I dispose of the case. You, see, quashing is not possible because this very old
Bail
case
is allowed.
and trial is going on. I am not going to quash.
No, I'm facing the trial now, sir.
So therefore, you have filed the main petition for quashing of the FIR.
Passing the FIR, sir. You see the order, sir.
now we used to approve the
Very difficult. I don't understand how to make you understand. What is your case? Your main petition is for quashing of FIR. That I don't want to do because the trial is going on.
Trial is not started, sir, at all.
You prepare and
Trial
come.
is standing, sir.
Prepare and come. Next week, Rakobi. I can't waste time. You have to be sure about what you are saying. Yes. You also seek instructions. Please read it and come.
no, because now I think file is not open, yes, and name is not there. So has to be there.
You people don't prepare and come. See, at this stage, at 3 o'clock, if you don't know what petition you have filed. Yes. It could be disposed of within seconds.
But it is
Within not even more than 1 second.
2009 matter.
Thereafter also you are not reading. That's the pity thing.
Sir.
Monday, Tuesday, yes. Pain. Who is there? White order dated 30th January 2025. This court has directed issuance of notice to the opposite party, and also refer the matter for mediation before the District Mediation Center, Barampur, Ganjam, subject to the petitioner depositing 20% of the check amount before the trial court. The district mediation center Barampur has addressed a letter to this court. Is it placed? Who is placing?
Section report, it is filed at
Placed before this court. And a letter dated 9/4/2025, placed before this court. The letter reads agenda. Letter reads agenda. Since the petitioner has failed to deposit 20% of check amount as has been directed by this court dated 30th 2025, the mediation process has not could not be initiated by the mediation center, district mediation center. In view of the same, the petition is dismissed. Yes.
68.
State my process. On 20th January of 2023, my lord passed the order in para 8, my lord.
Para
8.
Yes.
To deposit 50,000 rupees before this
Para
court within period of 15 days. Requisite shall be filed by tomorrow. I intimate the petitioner, my lord. He said whatever the dues in FIR, that the 1,40,000 already in receipt, and by the OP number 2 is complainant in this case. And 1 lakh, that is whatever the dispute, they already sought that. I paid to the OP number 2, that is complainant matter. There is no dues there. And my lord, they want to settle the case. So
to bring them, settle them, because there was a direction that 50,000 rupees you pay.
but they already clear all the dues of the OP number.
Where from I'll get it? Merely saying, orally
But
saying you will not.
he will appear before this or file the affidavit. And one more thing that, my lord, there are and another thing, my lord, in para 9, the London Council for Petition found that there are 3 accused persons against.
See, the problem is you have taken a stay, making a statement that I'll pay 50,000 rupees. And after the granted, now you are making different stories.
Stay is not working, my lord, because of not payment of the 50,000.
Then it's all right. You pay.
Call for the parties.
Call for the party then.
But only petitioner is there, my lord. The rest of 2%, we don't have any contact with them, my lord.
What can I do? Your clients.
I made a petitioner only party, and rest of person we don't know where. So in the FIR, there are 3 persons, my lord, 3 accused persons. I'm come from
let the opposite party. Let us see.
Yes, ma'am.
Let her come. Okay.
And my lord,
the
requisite may be accepted.
Yes, requisite already filed, be accepted, and sir, opposite party number 2 for service of opposite party number 2. Yes.
Okay.
Yes.
73.
As per last order, I have correct the name of the police station, my lord. I have wrongly written in the petition, my lord. Only that much, my lord, correction. I have filed the IF for modification of that, my lord.
No, modification of which order?
My lord, 5/3/2020.
Yes.
Thereafter, I have filed one IF for modification of that order, my lord. And last occasion on 28/3, you will be direct to correct the that
petition,
my lord.
Okay.
I have already corrected, my lord.
Okay. For the reasons stated in the application, the same is allowed. Whatever correction done.
Extension of time also.
In view of the aforementioned confusion, the petitioner could not surrender before the court as per the direction dated 5/3/25. 5/3/25. Let him let the petitioner surrender or before the court on before 30th. Okay.
74.
Lord, on behalf of Mr. D.R. Mahapatra, may I place this matter, Lord?
Yes, yes.
Lord, IA number 960 of 2025 has filed for modification of the order dated 12/3/2025. Your lordship has 960 of 2025.
Okay.
For modification of the order dated 12/3/2025, lordship.
12/3.
Yes, your lordship.
What modification you want?
My lord, your lordship has directed to deposit of 1,000 rupees before the Raigada Bar Association in total But inadvertently, it has mentioned each person has to deposit 10,000 rupees.
Not inadvertently, it is obvious.
No,
How
no,
many
your
of you are
lordship.
there? One, two.
No, well, I am not telling lie. On that day, your lordship has directed to deposit a sum of rupees 10,000.
6%, no.
Yes, your lordship.
I have quashed it.
Yes, your lordship.
Then pay 60,000 rupees to the bar. What is the big deal about?
The informant, where is there?
But
So what do you are not paying, they will pay.
Specifically at the time of hearing, only the present petition number 4 is that my lords are concerned, the ex-MLA.
How are you concerned?
My lord, I am informed. In that hearing, my lord, I am present at the time.
I'll see the dictation. এটা দেখিও যদি dictation each লেখাই ছিল each লেখাই see he says dictation.
Yes, madam, sir. I was also there. My lordship was directed each person has to pay 10,000.
No, my lord. Each person has to pay to OP number 2. But regarding the bar association deposit, your lordship has directed to yes.
Each person to OP number 2, there is no problem for you, huh?
Bar association, each person has to pay 1,000 rupees, my lord. But instead of 1,000, it has mentioned.
No, the kind. Just see the order, read the order.
No,
it's very clear. Read the order.
Yes, your lord.
Regarding head to the nature of allegation and the status of the petitioner,
yes.
I am of the considered view that the petitioner should pay cost of rupees 10,000 each to the opposite party number 2, and the same time deposit equal amount of 10,000 rupees each before the district bar association Raigada. It's not mistake, it is very consciously done. Give it.
Another prayer, may I pray before?
Huh?
May I pray another thing? Instead of Raigada Bar Association, it should be deposited in the Bargad Bar Association, because the Bargad Bar Association.
1 minute. Item number 74. 24, no? Bargad, why Bargad?
The petition number 4 was the ex-MLA of the Raigada constituency. But in the meantime,
where was the FIR?
FIR, Millard, main petition, Millard, page 10.
Devgar. Yes.
But subsequently, the matter has transferred to in the Bargad Bar Association.
Bargad?
Yes, your lordship.
The order is
Bargad. So the amount should be deposited before the Bargad Bar Association.
But it is pending before Devgar.
Yes.
Special Judge Devgar.
Yes.
I am clarifying my lord, though the present petition number 4 is ex-MLA, the case is transferred to additional district session judge Baragad, and that has a renumber at city case number 24 to 2023 lordship.
It should be deposited before Bargad. Huh?
Bargad, and also ma'am, I will change
city case numbers.
Court name, my lord.
City case number.
City case number and court name.
See, for the reasons stated in the application, the same is the petitioner is directed to deposit. Petitioners are directed to deposit the cost of 10,000 rupees each before the district bar association. Bargad,
Bargad.
Instead of Raigada, Bargad. And the city case.
City case number 16 of 2022, it may be substituted at city case number 24 of 2022-23.
Okay. Hello. Yes.
Would like
76.
75.
70?
A compromise. In fact, it's not compromise in the sense.
Yes.
But here the petitioner has challenged the proceeding under annexure 1 manner. Well, petitioner and the victim both are residents of one village as per the affair. And there is victim says she had married, there was a marriage between her petitioner and the victim. And there was some dispute between.
Who are they?
Family members of the victim.
You're the informant.
Victim or accused?
Accused
Who are they?
accused has also come.
You're the informant is only one person. I don't know why. they-
Accused is one, but who all are they? So many people have come.
See the height.
The mother has come.
Compliance of 42?
42.
Yes.
Yes, my lordship, 40. Page number 136, 134, my lordship.
Yes.
On 29/1/2021, I was posted as SI at Town PS Bolangir. On that night,
Who is he? Is the IO?
yes, my SI, my lordship, who has got the information.
Yes.
On that night, about 1:30 a.m., I was on patrolling, my lordship. I was on patrolling duty with my staffs. I have not got the information when I was in the police station. When I was on the patrolling duty, I got the information. I received the information that one vehicle bearing registered number so and so was coming from Santala side, Ganja. So I was on a patrolling duty. Then immediately I informed to my superior. What is section 42 says? You have to.
Where does he say that he is?
Yes, ma'am. I intimate about the information to IIC Town PS, IIC Meds SD entry, and intimate the matter to SDPO and SP Bolangir as well as to the SDM Bolangir.
Yes.
We watched near the Bolangir traffic post. After some time, one maroon color Ford Endeavour car bearing registered number so and so was found coming from Titlagarh side. We detained that vehicle. Both the accused standing in the dock, namely Santosh Singh and Ramanand Chaudhary, were present in the car. Person were not present in the vehicle, and that no contraband article was seized from them, and that I have lost the report implicating the present accused. He has not mentioned which article is present in the court. He is saying only that articles, and here he has confined it is a contraband. Articles. And he is saying that the PW 18 also not supported. My lordship, kindly belongs on 29/1/2021. While I was posted on SI Town PS Bolangir on that date, 2:20 p.m. SI Bijit Vehera presented a written report before IIC because he has informed to IIC Town. So SD entry is there, and it was exhibited. Who registered PS case number so and so under section 20B2C NDPS Act and directed me to take up the investigation. During course of investigation, I visited the spot and prepared spot map, examined the complainant and other witnesses at the spot, arrested the accused person, namely Santosh Singh and Ramanand Chaudhary, intimate the family members of the accused person regarding their arrest, seized one common certificate on production by ASI BM Sadangi, examined other witness on so and so date. I forward the accused person to the court, produced the seized exhibit before the court. Sample was drawn. Sample in the court, in the view of the order, in view of the order of the court, the ganja packet, white exhibit A and exhibit B kept in the PS Malkana, and the sample packets exhibit A3, exhibit B3 were sent to SFSL Bhubaneswar, and exhibit A1, exhibit A2, exhibit B1, B2 were sold inside the exhibit A and B respectively. And all the and all they have seized, my lordship. The chemical report also exhibited, my lordship. So this is clearly stated that everything has been recovered by that person. So accordingly, my lordship, the judgment has been. So he is saying that 42 has been not complied, and section 50 he is saying is not complied, my lordship. There is no question, my lordship, because it is not about the personal seizure, my lordship. Because the ganja was recovered from the vehicle. Personal seizure is not from the pocket of the petitioner's match. It is from the 50, my lordship, kindly belongs to the section 50.
Section 50 কথা কইলে section 55
Let me 55 also.
50 not
Conditions
50 not
under
correct.
such a person.
50 not correct.
Written notes to be written. police to take the charge of the article seized and delivered. I have already, my lordship, here says that I have seized the contraband ganja, my lordship. I have read of the PW 18, my lordship, who is SI of the police, who has taken the charge from the ASI, my lordship. Here says that the paragraph, may I read again, my lordship?
Yes.
On 30/1/2021, I forwarded the accused person to the court, produced the seized exhibit before the court. Sample was drawn in the court. In view of the order of the court, the ganja packet, white exhibit A and exhibit B were kept in the PS map. Everything has been seized, my lordship.
Yes.
The seizure is proved, my lordship, and that has been exhibited. That was when, and magistrates also proved that the seized ganja was when, my lordship, if you will see the deposition of the magistrate also, it was also proved, my lordship. It is not
Have you prepared written note?
my lord. I will
Prepare written note. Or rejected.
and in 125 page.
Movement will not, what my lord, that is not submitted. I have what I submitted, section 42, not required at all, because it is public place. If governed by.
You have relied upon many judgments.
Yes. But some sort of the Miller 42 to required Miller, what my friend submitted that the after getting information, the concern ISC noted down in the cell and made a station diary and sent to the SDPO and SPO. But to that effect, my submission that was required. My submission was that nobody from the office of the Miller SDPO as well as the SP who received that Miller station diary not been examined as the witness. Apart from that, Miller, my friend submitted Miller that IO Miller informant, he only received the information. He has not required to see the contraband activity. That Miller I had submitted on the Miller deposition of the PW 18 IO in Miller Cross. Same thing, Miller. What my friend read Miller, he everything Miller narrated Miller in his deposition Miller chief. So I only arrest only command certificate only nowhere he stated that I see the contraband activity. I informant information पाइली जो लोग अपन चला के देवो किए कौन सा सीट करो तो ना से आयो करो to fact the deposition of the Miller 18 Miller.
Yes.
It is a fact that prior to my investigation, the seized articles were received in our police station. It is a fact that prior to my investigation, the seized articles were received our police Malkhana. I have not examined the Malkhana in charge who received those articles as seized Miller. My case Miller said custody Miller. The contraband article has not been seized from the Miller possession of the present petitioner. So
exhibit, which exhibit is that? Exhibit.
And so also Miller.
Tell me the exhibits.
But
the exhibits are there, para 2. Which exhibit? P?
Malkhana register. Page number 76, my lordship.
I have not produced.
My lordship.
One thing, Miller, for a moment, Miller, look into the judgment of the Harendra Mandal case. Very specific point, Miller. Brass seal handed over to PW3, not produced in the court during trial. Seized gunny bags containing ganja, which were kept in the court Malkhana, were not produced. Accused is acquitted. And in this instance case, Miller, the same has been done by the prosecuting agency. Not produce the brass seal, Miller, that is handed over to the.
Stated that I have received the brass seal, and in page 136,
Magistrate PW 13 reference it is a fact that the articles were not seized at the spot.
Articles.
Articles. It 19. It is a fact that I have not produced the brass seal before the court at the time of production of the seized articles.
It is a fact that I have not produced the glass seal before the court at the time of production of the seized articles. And so also below the Malkhana is register also not produced at the time of trial. And on that ground below, the Hon'Ble Mandal case is unable to accepted the accused person.
And my lordship, all the seizure has taken, or whatever has taken place between 4 AM to 4:30 AM, prior to sunset.
No, what he says is PW 18 is the IO. He doesn't say that he has seized the contraband. And the two seizure witness, which those who could have supported you, those who have turned hostile. Malkhana in charge was not examined. Malkhana register is also not exhibited. So where is the seizure then?
And I register is exhibited. And one thing, my lordship, it was taken place at 4 AM to 4:30. My lordship, kindly have a glass.
See, let us see the exhibit.
Yes, my lordship.
Let's see the exhibit. Malkhana exhibit is.
My lordship, exhibit P6 scissor of the Malkhana register. Scissor list. Common certificate, my lordship. And in exhibit 15, there is a brush in my Jimana.
None of the original register and documents sealed by me are produced in the court book. During course of trial, Malkhana
But that in the cross examination, no.
The fact to my these sealed articles were received in our police Malkhana. I have not examined the police Malkhana in charge who received those sealed articles. I cannot say who endorsed the concerned entry in my Malkhana register, and I have not cited them as charge sheeted witnesses nor examined them. Hello, register to the exhibit question will go to the endorsement kala sekata will go na the
Exhibit P2. Just see exhibit P2. The exhibit P2. Yes, madam, exhibit P2, yes.
My lordship, cross examination I'm written. It is not the fact that.
See the exhibit P2. Do you have exhibit P2? Just check the exhibit P2.
Signature of PW 106.
Yes.
Signature of PW 160.
By this exhibit, the contraband ganja was seized. And it has been exhibited in the column 13, if you see. 2 bulk ganja bags marked as exhibit A and B. And 4 numbers of sample packets exhibit so and so. This is exhibited. That is what the exhibit P2. Why exhibit P2 read the evidences? Exhibit P2, who has proved this?
Again. Exhibit
P2, the signatures are there. Who all are the witnesses? How this exhibit is proved on record? Check it and tell me.
Yes, my lordship. My lordship, kindly have a glance to the PW4.
PW4. Yes.
On 31/2021, I was walking in my presence post. On that day, about 7:15 PM, one Malkhana register was seized by SI Surendra Kshatriya from Vijay Behra. This is that scissor list marks as exhibit 6 and exhibit 6(1) in my signature there.
Who has proved exhibit 2? You tell me first.
Exhibit 2.
The said Malkhana register is not available in the court today. Say PW4.
Come to PW2.
PW2, my lordship.
He says nothing was seized by the police in my presence.
In my presence. But
these are my signatures marked in exhibit P2. Exhibit 3 and Exhibit 4. He has not supported you.
My lordship, yes, yes. Plus to be the witness in the seizure of Ganjar and the traffic office truck a vehicle was detained and in the presence of the executive officer and other staff member, police assist 2 numbers of bag containing 24
It is the fact that on the instance of the police, I had signed that. And I had no knowledge about the contents of the document.
Suggested.
See, quality call.
PW1 is also similar.
It is a fact that on the instance of police, I had seen.
Not that part also there, yes.
PW3 also same, Mila. I know the contents for the document which I have signed.
Madam, there you have to clarify.
Regarding my
Seizure.
my lordship, it is proved, my lordship. Everything has been seized in the which has been exhibited. Magistrate has also proved that
Two witnesses, seizure witnesses have not supported your case. And the seizure document is Exhibit 2, which has not been proved. IO doesn't say anywhere that it was seized by me. Malkhana register is produced, but the Malkhana in charge was not examined. There are so many things to be answered. You have to prove beyond reasonable doubt. He could successfully created a doubt, small doubt, of course, but doubt. Now, please see it. Shall I put it on next week again?
yes.
22nd. 22nd. I'll dispose of the appeal. Substantial time we wasted.
Yes.
Okay.
My lordship, one thing can be done, my lordship. I will
Prepare the written note also
My lordship.
and give him the copy. He will reply to
yes.
that. Part heard? Partly heard. Leave the matter on 22nd at 3:30. Yes. I would have released you on interim bail, but he is from Bihar. He will never come. I have seen it.
5 years considering the
So then he'll see that sufficiently I have undergone, I will not come.
Minimum sentence
Yes. Both the appeal can be disposed of.
Yes.
Yes. Yes.
That's it. I have specifically.
Safe custody will not required. And you, some sort of 42 not required at all is a public place. Some sort of 42 is required, not compliant. It will not examine the higher official staff, Miller. Apart from that, Miller, entire case of the prosecution is also doubtful.
Save little energy for 20 seconds.
Specifically date and the birth certificate.
I did books. So,
Yes.
Yes.
77.
And on APS. Non-APS for the video. See, this matter was dismissed in default. Now restored. Again, he is not coming. I have restored him.
Yeah.
Again, it will be dismissed in default. Again, you will. By order dated 17/3/2025, the CRLMC 195 of 2018 has been restored to its original file. However, the matter is when the matter is taken up, we will non-acquiesce for the petitioner in the interest of justice. Adjourned. Yes.
28.
Yes.
Petitioner here challenging the order dated 24/8/2021 passed by the learned district judge Jajpur in criminal division number 20 of 20/21.
Speak little louder.
And petitioner challenging the order dated 24/8/21 passed by the learned district judge Jajpur, whereby the petitioner was before the court below is a complainant, my lord, and the opposite party number 2 is the accused. The accused recall is allowed, and he is not coming to the court for deposition, for which the matter is prejudice before the court below, and petitioner is being agreed of that recall order. Petitioner is before my lordship.
Where is that order?
Well, and that is.
It starts from page 8. It starts from page 8.
Page 8, my lord. That order is page number 10. The criminal evidence is allowed without cost. The order dated 27/2/2021 passed by the learned Jajpur, JMFC Jajpur in 1cc number 30/2016 hereby set aside, and the accused person be given one opportunity to examine himself and prove documents, if any, on the same day, and the learned advocate for the complainant is permitted to cross-examine him. Since this case is a case of 2016, the learned magistrates have do well to dispose the case by the next one.
How are you agree?
My lord?
How are you agree by the court?
Lord, he is not coming for deposing, my lord.
Date has been fixed. Yes, yes, Mr. Behra.
That trial has been stayed by this honorable court since 26th October 21.
26th
Proceeding has been
October?
2021. Lord,
In this case, he has challenged this.
yes,
And got a stay.
got the stay. Lord, your lordship, I will draw your lordship's
Where is
kind
that order?
attention.
Stay order. Just give me the stay.
Order number 2 dated 26/10/2021. Now, for one day, the Lorna district judge allowed me to prove my document, and and this proceeding has been stayed at the instance of the present petitioner since.
I vacate it and go. I'll fix a date. When can you appear?
Yes, your lordship, fixed date.
Everything and go and dispose it up. You have given
Yes.
it that he is not coming. If you got a day stay, how will you go?
But I was not working. I was not aware of this stay order.
You got the stay, then how we can go?
But I vacate the stay and let the matter proceed.
I fix a date when you tell me. When can you go?
Any date you will also make a fix. I have no, but these circumstances where this my 311 petition has been allowed by the
I'm not going into all this thing. Wait.
Yes.
Petitioner is agreed by the order dated 24/8/2021 passed by
District and Session Judge Jajpur.
Jajpur in criminal division number 20 of 2021, whereby the order of order dated 22/7/2021 passed by JMFC Jajpur in
Jajpur Road, my lord.
Jajpur Road,
Jajpur Road.
1cc number 30 of 2016 has been affirmed. Has been affirmed. The petitioner
Affirmed. That was set aside. The rejection. My
petitioner moved an application. You are the
Complainant for the court.
who is the accused?
Accused is Prashant Das.
Yes. Prashant Das. The accused with the opposite party number 2 in the present case moved an application under section 300 of the CRPC to recall BW1. BW1. The same application was rejected by the JMFC Jajpur by the order dated 22/7/2021. Therefore, the accused petitioner, accused opposite party number 2, filed a criminal division before the additional sessions judge put in.
No, before the Malone District and Session Judge
Session judge.
because the additional session judge was in quarantine because of COVID affected. That is why the matter was taken up by.
Shall I write everything? Wait, hold on. Division, being criminal division number 20 of 2018. The revisional court by order dated 24/8/2021 reversed the order to the JMMC and passed the following page 10. Page 10. Page 10 order. The counsel for the petitioner submits that despite the fact that the regional court has directed, the regional court has recorded one opportunity, one singular opportunity to the petitioner to examine himself as the W1. However, the accused has not been appearing and the trial is not. And she further suggests that the order of the sessions judge in the revision number so has actually finally, however, the benefit of the state order has not been waived by the opposite party deliberately to delay the proceedings. Mr. Behra, counsel for the petitioner opposite party number 2 submits that by the instance of the petitioner, the present petition is filed and by the order dated 26/10/2021, the operation of the in order dated 24/8/2024 passed by the Judge Road in has been stayed. Therefore, and the stay is operating since 2021. That's the reason the petitioner could not examine himself to one person, read out one as per the revisional order. Therefore, the retribution of the petitioner that the deliberately the party is delaying the proceeding is misplaced. I have gone through the material police before this court, material police of the court, and also peruse the impugn order dated 26/10/2021. It is true that in fact, because of the operation because of the operation of the impugn order dated 26/10/2021, the revisional court order could not be carried out. In that view of the matter, it is between the parties that both the parties that appear before the trial court on or before 30th of April 2025, and the trial court shall fix a particular date and afford opportunity to the opposite party to give its evidence as per the order dated 24/8/2021 passed by the revisional court. Revisional court in criminal division number 20 of 2020. With this observation, the petition is dismissed. Yes.
Trial may be targeted.
Yes.
Trial may be targeted. Trial may be.
You got SC-21/25.
That is wrong.
What is the use of it?
Let the trial may be concluded within a specific.
I have said that only one opportunity. As per the direction of the yes. Please put up.
May I please? It's application for question of entire proceeding. The ground.
This case, your lordships have asked me to assist your lordship. Yes. Right. Challenge is the revisional order. I mean, the petitioner is here. Yes, he's there. Yes, madam.
Please stand behind him, no? Stand. Yes, if he will ask you something, then yes.
In fact, he's challenging the order passed the criminal revision on the ground that the revision has been disposed of, directing to appear in the protest petition, and that the notice also has been sent in the protest petition. Now, for your lordship's better understanding, brief facts is important. In the year 2021, he had taken a house on rent. His neighbors allegedly screamed at him and got hooligans from outside, and they all conspired together and started abusing him for whatsoever reason he doesn't know. He went to the police station. The police did not take the FIR. He filed a complaint case. Now, in the complaint case, the magistrate, he stated before the magistrate that I had gone to the police station, and in fact, the police may be investigating the matter. For that reason, the magistrate stayed the complaint petition proceedings under section 210 of CRPC and asked the police for a report. Now, day after time and again, the police took time, the prosecution took time to give the report, police report. So lastly, he went to the criminal revision court asking to take action against the erring police officer because he is not complying to the order of the magistrate. But by the time revision court took up the case, the police report, the police had filed a final report in that case, stating that there is no evidence. So his grievance is that the police did not appear in the complaint case, and it is a perfunctory investigation. That is why the revision court should have reprimanded the police and taken up the case by itself and issued summons to the accused. This is the sum and substance of his allegation. In fact, I have gone through the records. I find that the revisional court is not the competent court. Even this High Court cannot pass any order against the police officer. You have to educate everything in the protest petition. Yes. That protest petition, what he is alleging, that protest petition notice has not been sent to him. So that recording of the finding that the notice has been sent to the protest petition is error. That is how he has come up in now since you know about thing. Yes. That protest, yes, initial statement has also been recorded in that protest petition. In the complaint petition, rather. That complaint petition we treated as a protest petition, and accordingly the magistrate may proceed. That will suffice.
I think let him file a press petition. He'll get a press opportunity of hearing that statement. You may add something in the minute. That's that with the position of law is that complaint petition should be taken. Yeah, you're right. Yeah, that was state. Yes. Well, that was yes. That was state. Yes. So, shall I dispose that thing? My lord.
Press petition against the police people. The finally return here जो as a complaint case to proceed. My It is about the protecting the proceedings. Saying that चला CLMC आसिया जाए revision एते date चला wrong order dismiss कर दे एते dates गला complaint case किसी police against action ले. So these grievances against police basically.
That's right. That you are a practicing law, no? You practicing law.
Yes.
So concentrate some other things. You keep on making grievances against everybody, then you need problem for yourself.
In fact, that is the matter. If at all he had a grievance, that he could have filed in a separate petition before the High Court. But contempt petition also you can file alleging contempt of court, and that also can take cognizance of that. Ethere 482 रे they इतना नहीं करियो.
The police officer, he is advising you rightly. I can put it, if you want, I can put it for another day. Go by his advice. I'll dispose it up, no problem. Go by his advice.
My priority is my professor when the reports already completely reduce the order.
And you have grievance against the judge, you have grievance against the police, you have grievance against the neighbor. You tell me who do you like?
I should also disclose, 1 minute, I should also disclose that he had filed a writ application because he had written to the President of India. The Honorable President also had given direction to the Chief Secretary. So Chief Secretary did not take any action against the disposal of a petition and this before this Honorable Court. That's why he filed another writ petition, and that petition cost also has been awarded against him.
May be problem for yourself. You concentrate in your practice.
Again, you are going to
You started having grievance against the High Court of
President of India directly to the action on petition.
You pick up quarrel with your neighbor, then President of India will come and solve the problem. Don't do that unnecessarily. You are practicing, you are concentrate somewhere. Do some good job. You are there to give justice to others. Don't do that. Whatever advice the author is giving, go by that advice. See, everybody sitting here, everybody has some problem or the other. Doesn't mean that we will keep on fighting.
He says airport. He says that
don't take names like
this. Police final report has been submitted stating that they could not find evidence and that there is a malafide proceeding in as much as he wanted to bury a girl of the neighbor which was turned down. In fact, he says that neighbor happens to be 95 years old. He doesn't have a daughter.
That's it. I think okay, you think over. I'm just adjourning it for some other day. Speaking to Mr. Doctor, he will rightly advise you. Don't get misguided and find unnecessary reasons. Okay. I'll put it on 30th. He's giving you valuable time, and he has been sitting in the court floor for the matter. I appreciate the efforts he is making. And whatever advice he's giving, please take positive. Okay.
The name may be reflected in the cause list.
Very urgent matter. I have an MD. What is that matter?
We have 5 convenience
3:30. 20 seconds, 20 seconds. 20 seconds. 20 seconds. 20 seconds. 23rd. 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 23rd.
My lord, 85, your lordship also wanted to heard this matter today so that unnecessarily this litigation is pending and your lordship was pleased to direct twice for mediation, the informant did it over. May I pray your lordship to keep it for short date so that matter can be disposed?
Just that in the week commencing from 21st to 25, I will get all the. All these matters will be rejected in that month. Not in one day.
Yeah,
Get it.
that will do. And the model.
Entry model will continue. Wherever the entry model will continue, and I'll address in that week, 21 to 25.
Oh, let's.
I pray for same thing for item 98 year also. Release of money year also. That is coming in after notice matter. That's why.
Yeah, I'll tell you, release of that 450.
Yes, sure. Also.
Today I have passed the judgment. I have formulated the guidelines. Please read that.
Yes, sir.
Okay, please read that judgment. I have formulated the guideline. I have circulated to all the CJOs and.
But on next count, let it come and press admission at please.
Read the judgment.
Yes,
directly, maybe directly covered. I don't know. Directed parties to go to the house of the inquiry about matter. How that the solid well established. And they have I am already very serious. One of the other is I've seen. It's very bad. And I requested tomorrow. I requested both of you to go. Yes, madam. Yes. Tomorrow. Whatever, you can't do it to your own mother. I'll dispose it. Both request for the local servant for the ticket. It's poison that say, yes. Tomorrow. You think that's